Item 25, pronouncement of judgment. RSA 176 oblique 2009.
Not hard that dismissal of the adjudicator and therefore this appeal is dismissed.
Dismissed. Item 1, 2, and 3 for motion.
We have one matter, item number 4, my lord. As per last order, my lord, there is listed in admission column. So, my lord, we both party agree, my lord, we fix on an admission column on.
I'll just tell you, Lordship, what happened on the last occasion.
It doesn't matter whether it comes to for admission or any other column.
Okay, my lord, actually, I was not fully prepared today, my lord. This, so, my lord, only one day, my lord, accommodation, my lord.
One day of week is again the reading of the same file again and again.
Yes, my lord, that is true, my lord. Very good. I was under impression that this because of last order, my lord.
You are sharing application for this because of the application filed by you.
Well, so last occasion, my lord, it was not part, my lord. Entirely matter supposed to dispose of it.
See, is there a guarantee that item number 1 in today's board I can be able to hear it? Is there a guarantee? Item number 1.
Yes, my lord.
Is there a guarantee?
One day.
God has not given us lifetime warranty.
That is true, my lord.
Right. It all depends on these ways. Whether I can hear it after 5 minutes or not, nobody knows.
Only one day accommodation, then on 9th, my lord, 9th.
Comes up to 2 weeks.
Like, my lord, he's coming from outside, my lord, so, my lord.
No, I'm here. I'm available. There is an urgency on my part also. That's the reason. In fact, on the last occasion, it was expressed in the court itself that it should come up entirely because stay was filed long time back, never pressed.
No, it is praised, my lord. Well, but there's an order for they file it's an affidavit also, my lord. Last occasion, also, my lord, is supposed to praise, my lord, but there is an order. My lord. Yes, but the rest is there, but it is. I have seen, my lord. I've seen.
See,
I've seen, my lord.
last week also.
Yes, my lord. List them in admission column.
Those you are not prepared on that day also.
You know, actually, I was prepared for IM, my lord. And
Immediately a time matter for hearing.
yes, my lord.
I will be dismissed.
My lord, then maybe hard to them itself, my lord. Yes, ma'am. Yes.
Hey,
At 2 o'clock we'll take it up.
2 o'clock.
Yes, ma'am. Yes, ma'am.
May it please your lordship. My lord, a listing for urgency and tomorrow, my lord. My lord, what had happened, my lord, the arbitration order, my lord, had passed. My lord, the proposed arbitrator has passed an award on 10/11/2023, where, my lord, he has interpreted clause 20.1 and 20.2 of the agreement. And my lord, as per section 12(5) schedule 7, serial 16, there is a legal embargo in it. In fact, my lord, what my lord's view had been on that day, it was similar view in Gujarat High Court. However, when the matter went up to the Supreme Court dismissed the order of the Gujarat High Court. So, my lord, maybe tomorrow, because my lord, as per that order, I was supposed to take steps within 3 days. So, my lord, may tomorrow, man. Much obliged.
May it please your lordship. Lordship, I beg to mention a listing of a writ petition. The matter pertains to demarcation of a plot of land, lordship. Lordship may fix it for admission hearing on the 2nd week of May.
that did it.
Much obliged.
Lordship, I pay for listing of a disposed of IA, my lord. Correction, lordship, this 2023.
Most of it.
The victim is on item number 9, my lord. Item number, kindly adjourn for a day, my lord, on behalf of BC, Senior Advocate BC Desmond. For 2 weeks, man. Bless.
Daily list item 1, 2, and 3 for motion.
Wait, please, your lordship. Lordship may take up, the writ petition 1975. The petitioner is a cooperative society, my lord, the Bru Dangari River Part 1 means Samobai Samiti, my lord. The society has challenged, my lord, lordship will find at page 114, my lord, annexure 21. Challenge the order dated 21/3/2024 passed by the registered cooperative societies. Well. Yes.
They presided over this meeting. So that was set aside.
No, my lord, they did not preside. In fact, president and president was removed, my lord.
You look at this
Lordship may-
order,
Lordship may kindly come
such,
to,
such meeting shall not be presided over by so and so. And
The-
several,
Lordship is reading, my lord, which paragraph?
page
Which-
114,
Yes, my lord. 114, order dated 21/3, my lord. My lord, this order pertains to, my lord, 25/9/2023, my lord, wherein, my lord, the society took resolution to remove the president, my lord.
yes.
Lordship may kindly come to, my lord, the page 69, my lord. Page 69 is the resolution, my lord.
Page number
Page 69, my lord. Annexure 12.
59.
69.
69.
Here, my lord, total 12 numbers of board of directors were there, my lord. 12 numbers of directors. Out of those 12 directors, 8 directors present in the meeting. Ranjit Das was the president. He did not appear. And Biju Chaudhary was the vice president. He also did not appear. In that meeting, Jiten Das presided. my lord. Please, my lord,
Yes.
my lord, 25-9 proceeding was cancelled, my lord, on the ground that provision of section 36(4) is not followed. If your lordship permit me, my lord, I may read the.
Yes.
36, my lord.
Yes.
Subsection 4, my lord. The board may, by a resolution passed by 3/4 majority of the directors present and voting at the meeting held for the purpose, remove the president or vice president. Such meetings shall not be presided over by the president or vice president against whom such resolution is to be considered. So, my lord, the president and vice president then did not preside at that meeting. And in that meeting, my lord, eight directors were present, and all of the 8 directors unanimously resolved to remove the president. So, my lord, there is no question of violation of section 36, subsection 4. And moreover, my lord,
So just a moment.
the lordship, as per
Yes.
section 36, 4, my lord, 3/4 of the 3/4 majority of the directors present in the meeting. So 8 directors were present, all of them unanimously, my lord, resolved. And subsection 5, my lord.
Yes.
Subsection 5 says that, my lord, the president or vice president, as the case may be, aggrieved by the resolution passed under subsection 4, may appeal to the registrar within 30 days. Here, my lord, lordship will find at page 113, my lord, annexure 20. Lordship will see to peruse the appeal petition dated 22/12/2023.
This meeting was held on 25/9/23.
25/9. The appeal was filed on 22nd of December 2023. After elapse of my lord, around 3 months.
Yes.
Now, lordship, the respondent number 4 taken a plea that he came to know only on 1/11/2023 about the resolution. But in fact, my lord, if your lordship come to page 65, my lord, page 65, annexure 11. The notice, my lord, issued by the secretary inviting the president, my lord, respondent number 4, dated 18/9/2023. He refused to accept this notice, my lord. Then notice was hanged, my lord, in his house. Lordship will find at page 68 photographs. '68 is the photograph, my lord. And purpose of the meeting was clearly informed to him, my lord. And notice was signed by the secretary, Vikas Das. So my lord, we have to come, my lord, go back, my lord, to the month, my lord, June. On Lordship will find annexure 1 at page 21, my lord. On 16/6/2023. 16/6/2023, my lord. The society had resolution number 1. Lordship will find the resolution at page 22. But resolution number 1, my lord, the then secretary Vikas Das was removed. And by the resolution number 3 at page 23, one Sanjoy Das was appointed as secretary. Annexure 1, please.
Who was appointed?
Malad Sanjoy Das.
Where is his name?
Malad Sanjoy Das is not party in this case. Malad he filed
No, which page is his name?
Lordship page 23, man. Resolution 3.
Yes.
Now, my lord, this resolution was challenged. Lordship will find as page 30, my lord, Assistant Register of Cooperative Societies had order dated 27/6/2023.
Yes.
Annexure, my lord, 2, page 30.
Yes.
May I read, my lord?
What is this?
My lord, the resolution dated 16/6/2023 was, my lord, suspended, and because that was allowed to function as
No,
secretary.
this is a challenge by your appeal.
Yes, my lord, appeal, because that's.
Yes.
So, well, because this was again restored back in the post of secretary. And thereafter, my lord, assistant register again on another application by them, my lord, on 4/7/23, my lord, again, my lord, withdrawn that order dated 27/6/23. 4/7/23, my lord. Thereafter, matter was taken up before the zonal joint register. Zonal joint register, my lord.
This is very fine. 4/7/23 is where?
Well, 4/7, I could not annex, my lord, because I could not found it. And thereafter, my lord, matter was taken up before, my lord, zonal register. Zonal register had order dated 5/7/23. vacated the order dated 4/7/23 passed by the assistant registrar temporarily.
Where is that?
That order also, my lord, I could not find out.
What is the date of order?
5/7/23. my lord. Temporarily vacated, my lord. And ultimately, my lord,
There should be a ban
my lord,
for 5 years to both of you to hold the post
my lord,
Lordship,
till next elections.
after he
Parliamentary
completes,
elections,
I'm
you
yet
should not-
to submit.
That's okay.
It's okay.
then my lord, I ultimately, after hearing on 14/7, that order finally, my lord, vacated. 4/7.
4/7.
4/7/23 vacated, my lord.
4/7/23 is vacated.
Yes, my lord. So, my lord, again, because
Who,
that's,
who vacated?
my lord, joint register. After, earlier it is temporarily vacated. After hearing on 14/7/23, finally vacated.
No. 4/7 order is vacated by
Zonal Register, Cooperative Society, Jorhat Zone.
yes.
Thereafter, matter was taken up, that Sanjoy Das, my lord, filed a writ petition before this honorable court. Lordship will find that, or find the order at page 32. This honorable court, my lord. Page 32, Annex 3. Ultimately, Honorable High Court directed the, my lord, the register to decide the issue.
Yes.
And my lord, in paragraph, page 34, Lordship will find that Honorable High Court clearly observed that, my lord, because Das was restored back in the post of society and he has been functioning as secretary, my lord. So he has the authority to issue notices and other on behalf of the society, my lord. Pursuant to this order, my lord, one hearing was conducted by the registrar, my lord, and ultimately Lordship will find at page 39, my lord. It arises from the above that the termination of Vikas Das as secretary and subsequent appointment of Sanjay Das as secretary of the society may deemed as illegal. In view of the above facts and statement made by the majority of the board of directors of the undersigned has come to conclusion that Sri Vikas Das is the present secretary of the society. 29/9/2023. Page 39 in the finding, my lord.
Yes.
So, my lord, this opinion, this finding, nobody has challenged, my lord. So it attains the finality. In the meantime, my lord, another proceeding was issued, my lord, challenging the, my lord, regarding removal of the then President Ranjit Das, my lord, the respondent number 4. Ultimately, appeal was filed, and my lord, appellate, my lord, authority said that termination was, my lord, illegal. So Ranjit Das restored in the post of president. Lordship will find at page 40, Annex 5, order dated 38/2023. Due to the tussle between the parties, my lord, annual general meeting, my lord, that is also, my lord, as per section 39, has to be, my lord, convened within 6 months, my lord, from the expiry of the financial year. So, my lord, the September is the, my lord, 30th September is the deadline, my lord. They have to convene the, my lord, annual general meeting. So, 8 members of the, my lord, society requested the secretary to hold a meeting, my lord, board of directors meeting. Ultimately, my lord, lordship will find that page 42, annexure 6, assistant registrar, my lord, directed the chairman, vice chairman, and secretary to hold the, my lord, board of directors meeting and to hold the, my lord, annual general meeting. 1st of September 2023.
Yes.
So, my lord, the secretary, my lord, being the secretary, because the issued notice to the, my lord, all the directors convening a meeting on 7/9/2023. My lord, lordship will find at page 46, convening a board of directors meeting on 7/9. On 7/9, nobody appeared. And ultimately, meeting was adjourned to 14/9.
Yes, ma'am.
Yes, 48 is the proceeding of the board of directors meeting 7/9, my lord. Annexure 8A. Then again on 14/9, my lord, another meeting was called, my lord. Lordship will find annexure 9 is the proceeding. On that meeting also, my lord, the president, Ranjit Das, the vice president, did not appear. 7/9 and 14/9 on both the occasion. So, my lord, 15 days notice to convene the annual general meeting. So ultimately on 14/9, they have decided to hold a meeting on 30th of September. Resolution number 2 at page 53, my lord. Or board of directors meeting 14/9.
Yes.
My lord, on 14/9, my lord, another board of directors meeting was convened by issuing notice by that Sanjoy Das, my lord, who was never, my lord, secretary. So he issued another notice convening a my lord, board of directors meeting on 14/9. On that meeting, respondent number 4 was also present. They have taken some resolution, and they have taken resolution that annual general meeting will be convened on 29, one day prior to the, my lord, the others. My lord.
Where is that?
My lord, the lordship will find it at page annexure 10, my lord. This is not, my lord, this is the my lord, letter issued by the register, my lord.
Page, give me the page.
Page my lord, 61.
51,
61.
60.
This is a letter issued by the assistant registrar to the president saying that the 14-9 proceeding cannot be considered, my lord, cannot be accepted. On the ground, my lord, the grounds are written, my lord, was first and second. They have co-opted some members because most of the members were absent. Because those members were present in the other meeting. So to maintain the quorum, they have co-opted some my lord, members as director. So Lordship will find that page 61, my lord, 1 and page 62, my lord, second ground. My lord, this should be no reports. Actually, there is some typographical error. My lord. No reports available in the office regarding posting of Sri Sanjoy Das as present secretary of the Dibru Dangari River Part 1 Mean Samavai Samiti. Hence, it is hereby asked to take necessary steps as per letter number so and so dated 14/7/23 issued by zonal register, whereby that resolution was vacated. Letter number so and so dated 38/2022 issued by register. Therefore, proceeding dated 14/9/23 submitted by you cannot be considered as acceptable. Thereafter, my lord, Lordship will find that Annexure 11, 18/9, my lord. That order, my lord, in my lord, issuing notice to the president. Holding a board of directors meeting on 25/9. Agendas were, my lord, election of president, but he refused to accept. Ultimately, my lord, he did not present on 25/9. So 25/9 resolution was taken to remove him.
How it can be helped? You see, when fish is in water,
Hello.
they can come anywhere. You can't stop fish from swimming in water.
And ultimately, my lord, the annual general meeting was convened on 30th September. Lordship will find that page 75. Whereby the resolutions taken on 25/9 was approved by the general body. Annexure 13, page 75. Resolution number 6, my lord. Annexure 14 is important, my lord. Lordship will find at page 95.
What is page 75?
My lord, the resolution step, but as per my lord 14/9, they also convened the meeting on my lord, general meeting on 29, my lord, 29. That meeting, my lord, cancel, my lord. They have challenged another, they have filed a repetition challenging that this also, my lord.
No, page 75 you showed us. What is page 75?
Yes, page 70, sorry, my lord. Page 75 is the my lord, proceeding of the annual general meeting dated 30/9/2023.
Yes.
My lord, in this meeting, the resolutions taken on my lord 25/9 was approved.
29/5.
25/9, my lord.
25.
whereby respondent number 4 was removed from the post of president.
Yes.
Now Lordship may come to page 95, my lord. Annex 14, my lord.
95.
95, my lord. The respondent number 4, my lord, in the capacity of president, my lord, on the issuance of notice by another secretary Sanjoy Das, they hold their, my lord, annual general meeting on 29. The proceeding of that
Mr.
meeting was
Bani-
cancelled.
Mr. Bani and Mr. Karika, why you are wasting time here? You have 1 or 2 days more, you can still apply for going to parliament. You have all the capabilities.
It's difficult when the government laughs, madam.
I think this is, you are before the
We
wrong forum.
represent the private litigants, of course, we can go, but the
You are before
government is
the
laughing.
wrong forum. You have a better forum there.
I'm yet to submit. madam.
So, my lord, this order was also challenged by the respondent number 4 before this honorable court. My lord. That petition is also listed before this court today, my lord.
Okay.
20 annual general meeting resolution 29-9 was, my lord, cancelled. Approval was not given.
Yes.
This is a subject matter of petition 6243, my lord. Thereafter, my lord, the 111, Lordship will find that page 97, 111/2023, Assistant Register directed the, my lord, respondent number 4 not to intervene in the function of the, my lord, society. Not to intervene, my lord.
Where?
Lordship will page 97, at page 97, Annex 15.
97.
Yes, as he has already been removed on 25/9, which was approved subsequently on 30/9/23. So he was directed not to intervene.
Yes.
In the meantime, my lord, the respondent number, my lord, 4, as although he was not in the post of president, he has been holding some, my lord, seals, my lord, seals of the society and some other articles. So he was issued with show cause notice annexure 16 and 17, my lord, but he did not responded. And ultimately, my lord, on 8/12, my lord, sorry, on 25/12, annexure 19, my lord,
No, just a moment. You were referring to,
annexure, my lord,
first is, you said about notice. What
yes,
notice?
annexure 18, my lord, show cause notice, as he has been, my lord, holding some office seals and articles, my lord. He has not
Page,
handing
give
over
me the page number.
page number 105, my lord. (103) and 105, my lord. Two show cause notices were issued.
Yes.
Then as he did not appear, my lord, on 107, page 107, my lord. Resolve Board of Directors meeting was, my lord, dear, my lord, on 25/12/2023, my lord. He was removed from the, my lord, post of the director also, as he was consecutively, my lord, absent in 3 meetings, my lord, as per section 43(7), my lord.
Yes.
So ultimately, now respondent number 4 is not director also, my lord. He is a simple member, my lord, now.
Yes.
So ultimately, my lord, the appeal, the file by the respondent number 4, my lord, appeal at page 113, my lord, appeal was not disposed of, not decided as because another writ petition, my lord, 6243 was pending. So he filed a review petition. Review petition was disposed of, my lord, cancelling the resolution dated 25/9. So he, my lord, filed now, my lord, another writ petition has also been filed, my lord, 2094, challenging that, my lord, he filed 2 appeals. One appeal, my lord,
Yes.
so, so 25/9 procedure, he was duly removed, my lord, following all the procedure, my lord. So, my lord, no illegality is there. Moreover, appeal is time barred. So that, my lord, order dated 21/3 is bad, my lord. And, my lord, he filed 2 appeals before the, my lord, register, my lord. One appeal has been disposed of. Other appeal yet to be disposed of. So, my lord, the writ petition 2094, my lord, is premature, my lord. That appeal is still pending before the register. In one appeal, my lord. In one appeal, my lord, he assailed the approval given to the, my lord, annual general meeting, 39/23. And another appeal, my lord, he assailed the resolution adopted on 25/9/23 and 39/23. So later, second appeal has been, my lord, this order has been passed, but first appeal is yet to be, my lord, disposed of. So this writ petition, my 2094 is premature to my submission. Let him.
May it please, Your Lordship. My lord, the issue involved.
Is
My
that
lord.
once you are in the chair, you want to keep it?
Not at all.
Not at all.
I must be democratically removed. That's all. It's not my chair. I have done it. My lord, there are 3 writ petitions before your lordships. Item numbers 1, 2, and 3. I'll present the facts so that connects all without referring to any particular page number or listed. Lordship may take up his writ petition, so we can go by the same page numbers. It will be easier. But difficulties came in 3 points. First, as my friend has correctly stated, it was as to who would be the secretary. A and B were there. By the names, they were Sanjay and Bikash. On a particular date, 16th of some month, they adopted 2 resolutions. By one resolution, Bikash was removed, and by the another resolution, Sanjay was brought in. Now, this was okay. But subsequently, the authorities of the Cooperation Department, in their own wisdom, sought to supersede each other's orders, thereby passing consecutive orders of stay. The effect of which was that I must concede that the removal of Bikash was eclipsed, suspended, stayed, not set aside. Now, the difficulty arose that there were two secretaries now, because Sanjay's induction was not set aside or recalled or reviewed by the authorities. However, the removal of Bikash was stayed. This bears an importance in the entire sequence of facts. Because at the first point of time, when two secretaries came in, the authorities chose only to touch the orders affecting Bikash, while they did not touch the orders affecting the induction of Sanjay. Now a stalemate came in. What was to be done? In result, this one part. Now, parallelly, another thing was brewing up. That was the president and the vice president, interchangeably, I may say the chairman and the vice chairman, were sought to be removed. The removal must be in a process warranted by law. And this also led to a big chaos. Eventually, a writ petition was filed on this court because appeals were pending, registrars were not taking a call, a writ petition was filed. And this honorable court intervened and said, so far as that would, my lord, would file in the second writ petition, he has not annexed it. In the second writ petition, page number 33.
Please give you number.
Page number 33 of the second writ petition,
Repeat the number.
6243, 6243 of 23. Oh, take them up. See, let's break it down. This is where the issues of the secretaries, Sanjay Bikash, and the chairman, vice chairman merge. As my lord there, page 33.
Page
33.
Yes.
And we invite my lord's attention to paragraph 10 at page 41. Or take my lord, paragraph 14 at page 42. Paragraph 10 would be relevant because it's how department stand. Paragraph 10 at page 41. May I read? Me?
This is Jorat or Tinsukia?
Tinsukia.
And the zonal in charge is.
Zonal would
Jorat.
be in zones.
It
Jorat.
will be in Jorat.
Jorat.
Okay.
Jorat zone. May I read? Paragraph 10. At the cost of repetition, my lord, with humility, the issues are twofold: secretaries and on the other side, president, vice president, altogether.
Yes.
Mary. Mr. S.K. Talukdar, the learned counsel appearing on behalf of the Cooperation Department, has drawn the attention to section 49(2)(1) of the Act of 2007 and submitted that in a case of dispute between the chief executive and the board in any manner, the decision of the registrar shall be binding on both. The learned counsel further submitted upon instructions that powers under section 49(2)(L) of the Act of 2007 reserved to be exercised by the registrar of cooperative society have not been delegated to any of the subordinate officials. In that regard, he drew attention of this court to a notification dated 23rd of May 12 to show that various powers of the Registrar of Cooperative Society have been delegated to his subordinates. However, the power under Section 49(2)L continues to be reserved to be solely exercised by the Registrar of Cooperative Society. He therefore submitted that the concerned responding authorities, that is, the Assistant Registrar of Cooperative Society or even the in-charge Zonal Registrar of Cooperative Society, could have passed the orders dated 27/6/23 enclosed as Annexure 9 and 10, as well as the order dated 5/7/23 enclosed as Annexure 13. He further submitted that it is only the Registrar of the Cooperative Society who could have taken a call or decided in respect to the dispute which has arisen out of the board's resolution dated 16/6/2023. With all fairness, the Learned Counsel of the Corporation Department submitted that the orders enclosed as 9 and 10, 13 are without jurisdiction. So the authorities concede that so far as the orders suspending or staying the removal of Bikash is concerned, they are without jurisdiction. This is stand of the department, my lord.
No, that means they're referring to the
They stay.
order passed by ARCS.
ARCS and the zone which stays the removal of Bikash. They concede that it's illegal. It's theirs then. Now paragraph 14,
Just
my lordships. The Honorable Court also observes on this.
just a minute. Where do we find this 5/7/23 order?
My lordship. Look, I said 5/7. No, 5/7, look, I said. 5/7. Must I be? No, 5/7. That is not there in the petition below, but it has been dealt with. Because that was a removal which was challenged way back in point of time. 9.
Yes.
My lord, this writ petition's number, the order which I'm reading, my lord, is 4083 of 2023. It has a reference, my lord. 4083 of 2023. And the order date judgment is dated 25th of July 2023. Now, may I read paragraph 14 onwards, how the Honorable Court dealt with it? Department considered how the court comes with it. Paragraph 14. From a perusal of the materials on record, it transpires that on 16/6/2023, the board of the cooperative society in question had resolved to remove the respondent number 6 in exercise of the powers under section 38(2) of the Act. On the basis thereof, a dispute arose between the respondent number 6 and the board. A perusal of section 49(2)L categorically shows that it is only the registrar of cooperative society who has the authority to decide a dispute between the chief executive, that is secretary of the cooperative society, and the board. It, however, reveals from the record that the Assistant Registrar of Cooperative Societies, Tinsukia, had, on the other hand, without any authority, issued separate communications dated 27/6/2023 to the Assistant Registrar M of the Office of the ARCS Tinsukia to make necessary inquiry in respect of the board's resolution dated 16/3/2023 and to the petitioner number 1, thereby suspending the board's resolution dated 16/3/2023 with the direction that till completion of the inquiry, the respondent number 6 be allowed to carry out the function of the secretary. Taking account of section 49(2)L of the Act of 2007, a prima facie appears that the exercise of jurisdiction by the Assistant Registrar of Cooperative Society in issuing both the communications in clauses annexes 9 and 10, both dated 27/6/2023, are without authority. My lordships, this is a pronouncement of by the Honorable Court. Therefore, if I may most respectfully submit, the removal of Bikash holds field rather than the chaos created by the suspension, because these orders are held by this Honorable Court not to be without any authority. Now the part as to the chairman and vice chairman. I read on. It further reveals that the communication dated 27/6/2023 by which the board's resolution dated 16/3/2023 was suspended by the ARCS was withdrawn by the said order dated 4/7/2023. Immediately on the next date, another communication dated 5/7/2023, Annex 13 was issued by the in-charge Zonal Joint Registrar of Cooperative Society, thereby again putting respondent number 6 back to the post of the secretary of the Cooperative Society, thereby temporarily vacating the communication dated 4/7/2023. This court expresses deep anguish in the manner in which the powers are exercised by the in-charge Zonal Joint Registrar of Society, taking into account 49(2)L of the Act. My lordships, so the power exercised by the higher authority also is to be held without jurisdiction by the Honorable Court. So we are back to 16/6 when Sanjay was brought in and Vikas was removed. Rightly or wrongly, the registrar ought to have taken a call. He did not, and the call taken by the other authorities were had to be bad in law. 16. It further shocks this court that on the very date, that is 5/7/2023, a meeting of the Board of Directors of the Cooperative Society was called and held at 11 a.m. A perusal of section 43(6) of the Act of 2007, read with bylaw 76A of the society, which mandates a 4 days notice to be issued. The council appearing for the respondent number 6, caveat, however, has failed to show any notice in compliance with the mandate of the Act of 7, read with the bylaws of the society. This court further expresses serious doubts in the manner in which the meeting of the Board of Directors was called, taking into account the stipulations contained in section 43(1) and 43(2) of the Act of 2007. On the other hand,
Just a minute.
my lordship,
This
my lord,
5/7 board is in which page?
my lordship.
Meeting of Board of Directors, 5/7.
5/7 document is not annexed in the repetitions because we are in a subsequent challenge because now because of the narration of facts, I'm reading the judgments earlier. In either of the in all repetitions, because since we are dealing with the facts later in down in timeline, therefore these were the earlier repetitions.
Okay.
But 5/7, two things occur. One, the Zonal Joint Registrar issued an order which touches upon as to who the secretary, that part, Vikas's part. That part, Honorable Court said no, without authority, the registrar should have taken a call. So we go back to 16/6 when Sanjay was brought in and Vikas was removed. That takes a call. Now, paragraph 18. This is the second part when two persons were removed, chairman and vice chairman. It is relegated to the registrar to take a call. In the meantime, there should be a stay. May I read the exact words? Paragraph 18.
Yes.
Be that as it may, this court also finds it relevant to taking into account that the resolution so adopted on 5/7/2023 in the purported meeting is required to be stayed pending decision of the appeal preferred before the registrar of cooperative society till disposal of the said appeal. This court having done so, taking into account that serious consequences would ensure if the said resolution dated 5/7/23 is not stayed pending disposal of appeal. Accordingly, board's resolution of the cooperative society dated 5/7/2023 stayed till the final outcome of the appeal preferred before the registrar of societies. The registrar of corporate societies further directed to dispose of the appeal within 15 days from the date of a certified copy of the instant order is served by either of the
5/7 is already rejected.
rejected. Well, no, what I'm trying to submit is that the secretary's part, who would be the secretary? That was dealt with by this honorable court in this order, which directs the registrar to take a call. So the secretary continues to be the same position, and so far as the chairman, vice chairman, they continue pending disposal of the appeal. They continue by this order. Thereafter, my lord, the authorities, if I may just hand it over, my lord. The assistant registrar of cooperative societies, Tinsukia. This I'm extremely sorry to give it this way, my lord, because on the last occasion when the matter was moved and argued at length, it fell through that there must be a connecting document to kindly check up. So therefore, we got it. I'm on that. This was issued by the assistant registrar of cooperative societies, Tinsukia, addressed to the additional deputy commissioner in charge Shodhia subdivision. May I read it, my lord? It's dated 3rd of August 23. Subject: affairs of the Dibru Dangori River Part 1 Means Saw by Samiti Limited. Reference: your letter number so and so 31st July 23. Order of the Honorable Guwahati High Court in WPC 4083. That's what I'm referring, my lord. Dated 25/7/2023 and the subsequent letter. May I read it? In inviting a reference to the subject cited above and in enclosing herewith in the light of the order of the Honorable Guwahati High Court above, the letter under reference, I have the honor to state that the Honorable Guwahati High Court in its order dated 25/7/2023 in WPC 4083/2023, while disposing the writ petition submitted by the petitioner, stayed the resolution adopted by the Board of Directors meeting of Dibru Dangori River Part 1 Means Saw by Samiti Limited held on 5/7/2023 and taken into serious views on the action of the in-charge zonal joint registrar of cooperative societies, Jorhat Zone, allowing Bikash Das to act as the secretary of a society which had been removed by the board headed by Sri Ranjit Das without his authority as per provision of the Assam So-and-so Act Run 7, and directed registrar of cooperative societies Assam to dispose of the appeal petition lying before him in the matter of the dispute. The dispute arises on the removal of the president, vice president, and the secretary of the society. In view of the above and in light of the Honorable Guwahati High Court's appeal before the registrar of cooperative societies Assam, which is yet to be disposed of, I am of the opinion that the board headed by the petitioner Ranjit Das shall remain in office, and Sri Sanjay Das shall act as the secretary of the Dibru Dangori River Part 1 Means Saw by Samiti Limited until and unless the appeal petition is disposed of by the registrar of societies in the hearing fixed by him for smooth conduct of the society without any disruption. My lordships, the authorities of the Corporation Department, without any ambiguity, hold that Sanjay would continue as a secretary. This is following the order of the Honorable High Court in 4083, which says the orders issued by the intermediate officers are violation of 49(2)(l) and therefore without authority.
Why this letter was generated in the first place?
I have no clue, Miller, but it refers to your letter, that is the additional district commissioner's letter, some letter, then order of the Honorable Guwahati High Court and letter from the registrar. But what falls true is that, what I could see now, since the initial case was 4083 was that the registrar is not taking a call so far as the removal of the chairman and the vice chairman is concerned. That was the basic case. However, in its sweep, the facets of the removal of the Bikash as a secretary and induction of Sanjay as the
This-
secretary.
This order would be absolutely illegal. Assistant Registrar of Cooperative Society,
My lordships,
he wouldn't have jurisdiction to pass his orders.
this
To
was an
declare-
opinion he conveyed.
No, that's why.
Absolutely.
why is it
I
illegal?
agree with your lordships. I was coming to that. I was referring to that. That this what intervened happened. Now, I do not say at that point of time who ought to be the secretary, but I can surely say that there should not be two secretaries. There has to be one secretary. 16.6 resolution, either Sanjay's induction stays or his removal stays. I mean, his removal is quashed or not, would have a bearing, someone would stay. So therefore, registrar has to take a call who is the secretary. Now, this letter, although sprung up, but however, it was after this honorable court's order and some communications between the authorities. Anyways, now if I invite my lord's attention to page 32 of the first writ petition, because the controversy loomed and persisted as to who would be the secretary. This was decided in Keyhole. And the first writ petition, 1975 of 2024. Show me that. Page 32. WPC 5512 of 2023. This was between the secretaries, my lord. So both Sanjay and Vikas were there. All represented.
Yes.
Well, this was by Sanjay Das, one of the secretary who was brought in. And respondent number 6 was Vikas Das, the other secretary. Page 33, the first paragraph, the lordship there. The central controversy. The central controversy involved in this writ petition pertains to the question of legitimacy of either the writ petitioner or the respondent number 6 to continue in the office of the secretary of the Dibru-Danguri River Part 1 Minsawbai Samiti Limited. That issue remained because in the other writ petition, 4083, his lordship had directed the registrar to take a call as to the removal of the secretary of the president and vice president. Secretary part never was touched. It is only by this communication that they had opinionated, correctly or wrongly. But since the difficulty was there at the ground level, we came to the writ petition. And that this is the answer to that. In the narration of facts, this honorable court recorded at the orders of states which were so passed. May I read that part? 2 paragraphs. It might be 11. It appears by resolution number 1 adopted in the meeting of the Semi Summit Limited held on 16/6/2023, respondent number 6 was removed from the post of the secretary of the committee, and as per resolution number 3 adopted in the said meeting, the writ petitioner was adopted as the secretary of the committee. Consequently, the petitioner had taken over and continued to function as the secretary of the Samabhai Samiti Limited. However, the assistant registrar of the society, by respondent number 4 herein, had passed orders dated 27/6/2023 suspending approval of disposal number 1 of the board of directors of the Samabhai Samiti Limited adopted in the meeting dated so and so, result of which respondent number 6 was restored back in the office of the secretary. When the above position was obtaining, the learned single judge of this court had passed judgment dated so and so in 4083 of 2023, which was instituted by the present petitioner and 2 others, thereby observing that the order dated 27/6/2023 passed by the respondent number 4 was without authority of law. However, it appears that since the subject matter in the said petition was pertaining to the question of validity of the resolution adopted with the board of meeting 57/2023, the learned single judge did not pass effective order interfering with the order dated 27/6/2023 issued by respondent number 4. Now, this is what had happened. His lordships in this writ petition had noticed that the issue in controversy was different in the other case. And therefore, although opinions were expressed, the decisions were not forthcoming. May I read further, madam? Today, when the matter is called up, Mr. Banik, learned counsel for the writ petitioner, submits that so as to end the uncertainty in the matter, the best recourse.
Just one,
My
where is this order dated 27/6/23?
But this put all in the earlier writ petitions, my lord. 27/6/2023 was the orders which the honorable court had said was bad in law because could be only exercised by the registrar. 4912.
This 27/6 was by ARCS.
ARCS. They could not have been exercised by any other authority except by the registrar. However, that was not the controversy, although opinions were expressed to be without authority. Therefore, the controversy remained. Lordship had correctly pointed out that there was no reason for this to happen. A call was to be taken by the registrar who is to be there. Absolutely. Therefore, we had come here. And court noticed that although some opinions were expressed, but no decision was taken. Following that, today when the matter is called up, Mr. Banik, learned counsel for the writ petitioner, submits that so as to end the uncertainty in the matter, the best recourse for this court would be to direct the respondent number 2, that is the registrar of cooperative societies, to decide on the question of legitimacy of the petitioner vis-a-vis the respondent number 6 to continue in the office of the secretary of the society. Since the AGM of the society is scheduled on 29/9/2023, Mr. Banik submits that an attempt be made to decide the said issue prior to holding of the AGM. My lordships, this is the first in point of time that the reference was made that the AGM is on 29. Just to who would be the secretary, kindly be resolved prior to that. It is not that it was done without any basis whatsoever, because notices were issued for the AGM and by the secretary holding the charge, that's Sanjay. I am not canvassing on that, but this is the factual narration. And therefore, that AGM is scheduled on 29 was, the Honorable Court was apprised. Now, Mr. Rajkot, standing counsel of the Corporation Department, as well as Mr. Hawk, led counsel for respondent number 6, that Vikas Das, have also fairly agreed to such a recourse. In view of the above, without commenting on the merit of the claims and counterclaims of the parties, the writ petition stands disposed of with the consent of the parties by directing respondent number 2 to decide the question of legitimacy of the writ petitioner vis-a-vis the respondent number 6 to continue to function as the secretary of the board. The decision may be rendered either by the respondent number 2 himself or through any competent officer authorized by him on that behalf. Whatever be the outcome of the exercise, the same be communicated to the parties in writing. Since the AGM is fixed on 29/9/2023, the decision in the matter be taken as expeditiously as possible, preferably before holding the AGM of the society. Notices may be served upon the parties, notifying the date of hearing, and personal hearing may be given to them if desired before the final order is passed. With the above observation, writ petition stands disposed of. My lord, as on the date of passing of this order, that is 20th of September, it's relevant, my lord, 2009/2023, who would be the secretary was not resolved. And this Honorable Court had earlier said that the orders touching upon the removal of Vikas were without authority. This is the stand. Now, page 37. There's a hearing conducted as to who would be the secretary. Got it there. I skip to page 39. The end of it. My opinion. That is 29th of September 2023. Lordship is there. 39, the last part, if I may read.
Just now.
My lordship.
This court directed the registrar to take a call.
Or by any officer authorized by him.
Where does it say that he is authorized?
It does not say so, but we did not prove to that further, my lord, because this Honorable Court had given that liberty. There must be an intercom official communication.
Yes.
My opinion. After the hearing, it is to apprise from the above that the termination of Vikas Das as secretary and subsequent appointment of Sanjay Das as secretary of society may be deemed as illegal. So removal of Bikash is held to be illegal and induction of Sanjay is held to be illegal. Sanjay conceded to it. The chairman, the vice chairman, everyone accepted it. No one disputed it. Even till date, it is not disputed that Bikash is the secretary on and from the decision. That is 29/9/2023, not a day prior. Because prior to that, whatever eclipse was there on his removal was illegal, unauthorized, pronounced by this honorable court, and not put to challenge in the division bench or in review. It holds water. Now, my lordships, if on 29th Bikash is the secretary, could he, I put this question to myself when at large, issued a notice of a meeting for removal of Ranjit on 25th? That's time traveling. Page 69. He could not have done that. Ex face badin. Page 16.
Page
16.
of
The same writ petition. I'm referring to this one, it will be easier for the same numbers to be there.
page 60.
69, my lord, 69. My lordships. This is a translated version as they had annexed below, and I do not doubt the translation at all. The date is at page 70, 70. That is 25th of September 2023. And resolution number 3, if I may read below. Today's meeting unanimously resolved to hold Ranjit Das, the president, guilty as per so-and-so of the Assam so-and-so Act and to terminate him as per provision so-and-so. Signed, Bikash Das, secretary. My lord, 25th of September, he was not the secretary. He was declared the secretary on 29th of September. I am on that. Therefore, this resolution of the entire meeting is vitiated.
It's a difficult proposition.
I'm open to it.
You see, when the appointment is held valid, it will correlate from the date of the appointment.
It would correlate certainly, but at the relevant point of time, Sanjay was operating, continuing to operate as the secretary.
But his
Big-
appointment when is
I
declared to be
understand.
illegal,
I understand what lordship has held at ab initio. I understand what is ab initio. But so far as 29th is concerned, on 29th is held that correctly, his removal is bad in law. This is held is. So it does not validate any act done by him when that position was being occupied by another. This was the only reason of the controversy, because on one hand, in the writ petition, this honorable court says that the orders, intermediary orders passed by the authorities were bad in law. So therefore, his removal remained. While on the other hand, correctly, this honorable court referred the matter, relegated to the authorities to decide, the registrar to decide. And he did decide correctly that this was bad. Nothing difficult. But since another man was holding a chair, two persons continuing would be bad in law. But I'll come to that later. What I'm saying is that as on 25/9/2023, certainty, with all certainty, a person cannot know that on 29th in the hearing, I would be declared as a secretary. I put it the other way around also. So therefore, the notice preceding the meeting itself would be bad in law.
You read today's newspaper. You will have already declared what would be the result. Even before the elections are over, before the
I
counting.
bow down to your lordship, Miller. I'm only an arguing counsel. On 25, if you had a sweet dream of having that 29th, I would be the secretary. So what I do would be validated on the principle that since my removal is bad in law, hats off to that, Miller. I could not say so. But if he thought so, brilliant. Anyways, so this is the first limb of the argument as I'm placing. So from 29th onwards, he continues to be the secretary. Now, another difficulty was parallelly creeping in. Because Sanjay was the secretary, he and the chairman Ranjit, because Ranjit was declared to be the chairman by the registrar on 30/08/2023. Prior to this, and they have also accepted it, no difficulty. Therefore, I was removed. So the registrar declares Ranjit to be the chairman on 30th of August. 1st of September, a notice for election. Normal notices are issued. Now, two sets of notices were issued. One, the declared chairman, signed by the secretary and the chairman, and the other by the secretary or Ranjit Das unanimously. I mean, unilaterally, without any power. Now, two things followed, but the AGM was decided to be held on 29th because the chairman had signed it. Now, this AGM, the proceeding of this was not approved by the authorities on the count that Sanjay could not have signed. Without taking into consideration the fact that as on 1/9/2023 through 29/9/2023, his position is not disputed by anyone. Therefore, the central controversy was referred to by this honorable court to the registrar to decide. The 29/9/2023 AGM, the action of the authorities in not approving the resolutions is under challenge in the second writ petition, petition number 2. Now, if this be so, the removal of the president on 25th by and under the signature of Bikash could not be validated because there was no orders validating his act as on that date. As on that date, 25th could not have been. So therefore, the chairman, which the registrar had declared on 38, had issued notice for the AGM to held. It's not election, my lord, it's AGM. There may be a confusion on that. It's AGM, not election. Definitely. 36, whatever. 36. My lordship. So, together, yes. The AGM had to be convened before 30th. Had to be convened. Otherwise, we fall on the 39th, second 39th. The board would go. And the fact that AGM is on 29 was noticed, submitted, and agreed to by all in the consent order. That 29th is the AGM. Kindly decide who the secretary is possible prior to that. Pausing for a moment, assuming the 29th AGM is held to be bad in law. Assuming. It's for argument's sake, Mila. My lordships.
What was that number? The reparation
1-2.
5512. Yes.
Well, if Lordship would also like to refer to, I mean, that how Ranjit came in by the order of the registrar, it's at page 40. Ranjit is the chairman. And they also accepted it. So they removed me later. Page 40. That is 30th of August.
Yes.
My lord. So the secretary, not being a secretary, could not have issued that removal really. Again, I must address this issue because this issue had loomed up. My friend, if I recall correctly, had said that 8 persons had voted. 8 persons. And had read 36-4 to show that it was the compliance was met. With Lordship's permission, if I may read that part, 36-4. Oh, this was argued in umpteen writ petitions, my lord. The purport of it, 36-4. The board may, by a resolution passed by 3/4 of the majority of directors present and voting at a meeting for the purpose, remove the president or the vice president. Such meeting shall not be presided by the president or vice president against whom such resolution is to be considered. It can be understood 2 ways. Total number of directors, 3/4 must be present and voting, or whatever number is there, 3/4 of that would do. If Lordship permits, I would test both ways. If whatever number is there and 3/4 of that is fine, then 1, 2, 3, 4, 5 are there on that. 3/4 of this would do. 4 are there. 3/4 of this would do. 3 are there. 3/4 of this would do. 2, 1. So 3/4 of whoever has come would not giving an objective purpose, meaning to that. 3/4 of whoever is present cannot, because suddenly 3 persons come and 3/4 of 3 would be whatever number is there and they would be fine. So this correct interpretation, as I'm trying to persuade my lord, is that 3/4 of the directors, number of directors must be present and voting. I leave it to your lordship. I leave it to your lordship. That is a different chapter. We can argue on that. What I'm trying to submit is that it's not that number of directors who have gathered, 3/4 of that would do. In the present case, it's 14 numbers. 3/4 of 14 must be present and voting. That's on the legal part. Anyways, I leave it to you. I'll keep it open. Because I will address that part if need be. So when the 30th of August, the president had been declared, you are the president. The president, along with Sanjay, had signed on 1st of September notices for the AGM. Similarly, without authority, if I may put it that way, or with authority, Vikas Das had also issued notices. This led to a situation where 2 AGMs were to be held, 29/9 and 30/9. 29/9 was held, but the resolutions were not approved on the count that Sanjay could not have signed. Assuming their understanding is correct, but it was rightly signed by the chairman. But Sanjay was continuing then So there is no difficulty on that. This is under challenge in the secondary petition. No, my lordships, as I was submitting a while earlier, even if 29-9-2023 fails on a point of law, on a point of time, count of numbers, whatever, a registered cooperative society cannot proceed at the whims and caprices of the officers or the members or the directors to hold simultaneous AGMs. They cannot. There has to be one AGM. Either it says or it drowns, it sinks. So even if 29 goes, the board goes. There has to be fresh AGM because they are hit by 39. One day goes. This aspect of the matter, this facet, did not reach did not get the proper attention. And therefore, we filed, and I would put it that way, statutory appeals before the registrar. Number one, saying that 30th September 2023, there could not have been an AGM, regardless of whoever signs it. Even if the correct secretary or the chairman or any other member signs it, there could not have been two AGMs. The first one either stays or sinks. The board goes or board stays. And the authorities, having not understood this part of the matter, having approved this resolution, we went to the registrar. Technically, he has argued the factum of delay, which I must address your lordship. If I was removed on 25th of September, then why did I take so many time to move to the registrar so long down in December? I have to address your lordship on that. The communication, I have pleaded in my writ petition, the third one, Milo.
Why do you say this board goes on 39?
What I submitted is that, if I rephrase my submission, 29th of September AGM was known by all and it was publicly notified to all. So the proceedings of the 29, the resolutions adopted can either be approved or not approved. The consequence of non-approval would be the board would go. There cannot be umpteen number of AGMs of a same society. One group says we'll hold on 29, another group says we'll on 30. That is not the way we proceed. The authorities, while rejecting to approve the resolution, do not say, and I must say, quite emphasizing this sentence, my lord, they say that by 710 they say Sanjay was not authorized to sign. Fair enough. If that is held good in law by your lordship in the second writ petition, the board falls. The AGM goes. There cannot be a second AGM. When the notices were being issued for two AGMs.
Is there a bar?
Yes. A society is formed by its directors and members. The directors are elected. Those elected directors have a bounden duty because they coexist with the term of the board. And the board exists when they hold the AGM as per 39 within 6 months of the close of the financial year. That's from 1st of April to 30th of October. If that AGM is held sometime, my lord, say in April, May, June, July, something wrong goes, they can hold. But at the last breath, when who is the secretary, who the chairman, all these things are going on, two AGMs proceed simultaneously. And the first AGM is allowed to be held.
First, the financial year starts on 1st of April.
I'm not on that. I said the time when the AGM is held is 29th of September 2023. The time when the AGM of held. The authorities ought not to have allowed either the first group to proceed or the second group to proceed. I am on that, my lord. They rejected they did not approve the resolution on account that Sanjay should not have issued the notice. We are challenging that. But at the same time, they simultaneously allowed both the horses to gallop, meaning thereby both the AGMs to take place. That was the error. We said crept in. Therefore, we had filed statutory appeals before the jurisdictional registrar, saying that the Honorable Court is in session of the matter, whether or not the rejection of 29/9/2023 AGM is good or bad in law. This is the second writ petition. So when the Honorable Court is adjudicating the issue, whether 29/9 is good or bad, kindly stay the 38/1 resolution. Whatever happens in this would have a bearing. The registrar got it the other way. Possibly, he thought that since the matter is sub judice, we will not touch anything. Therefore, we filed review, saying that no, this understanding was wrong. This issue is not before this Honorable Court. 39/2023 issue is before the registrar, jurisdictional registrar, who is the authority to decide. This issue is not before the Honorable Court. The Honorable Court is confined to 29/9 only. Now, in the review petition, which is taken up, which has three issues. The first one is that my removal and subsequently another chairman being inducted was communicated belatedly. And when communicated, I have put up in appeal. Your Honor did not accept, the registrar, His Honor did not accept the arguments and took it that the matter is sub judice, therefore the review was filed. Here, on the touchstone of 36(4), one part was held in my favor. Sudhanshu's induction was held to be bad in law. But the registrar was silent on the 39 issue and on my removal issue. Therefore, the third writ petition in the series was filed, saying that although we accept the order of the first part, but his silence on the other two parts touches upon my rights. Decide the rights this way, that way. In this gamut, this writ petitions are before your lordship. The first in point of time being the second writ petition, item number 2, which is whether the adjudication of the 29/9/2023, that's other two are by my friend and myself. No, my lord, on the point of limitation. Sitting on the Huh? And what from there? হেৰি আছে ন এইখনৰ লগাইছো ন আমাৰ ঘৰত লগাইছো এঘাৰটো খোলা সৰু থকাটো ওলাই দিম Yep. লিখি যাব ঠিক আছে One plus one, then it is. I think that's it. I think so. Russian. Everyone Tata Steel. I think ওইখানে সরকারি কপা দেখি দেয় সরকারি কোড দেখি এটা সরকারি কোড দেখি পাইছি 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 Yes, my lord. My lord, sure. Could I be clear on facts? The the communication from them about these developments of my removal and that another one was inducted was done officially through registered post. And we are on one page. If I say that this was issued on 6th of December. It was issued on, posted on 6th of December and received on 18th of December. They would agree to it. There's no difficulty. The originals I have got from the clients. I call them up to hand me over this envelope, which contains the date of dispatch, on which date it came to the beat office, and on which date we received it. 18th. The original is there. Number 5, Ranjit Das. Received by someone else, but 1812. . 12. So 1812 we got it. Thereafter we filed the appeals within the time period. Else it should have been a paragraph to explain the condonation. This is there. And the communication is at page 97 of the writ petition. What was there in the envelope?
Pardon me,
Page 97 of the writ petition.
the second iteration,
First writ petition, his writ petition.
90,
97.
yes.
And the pleadings to that effect is at page 12, paragraph 16 of the writ petition.
So what is this?
This is the communication which was there in the envelope, my lord. This is a translated version. The Assamese version was there. The vernacular one was there. But it's okay.
Okay.
In the pleadings, they have used the word request. There is no request. I'm informed and asked and directed to do so. That's the wording. The ARCS would not request me this. He directed. The vernacular as it treats me, Lord. উপরোক্ত বিষয় সম্পর্কে আপনার গেটারতে জনোৱা হয় যে ইনফর্ম এন্ড লাস্ট অফ ইট সেজ যে অনুমোদন দিয়া হৈছে গতিকে আপুনি সমিতিৰ উপবিধি আৰু অসম অমুক আইন 2007 অনুসৰি ধাৰা অনুসৰি সমিতিৰ খনৰ সদস্য ক্ষমতাৰ পৰা বিৰত থাকিবলৈ জনোৱা হ'ল. I'm just told, directed, not requested. So this is there. The moment I come to know, I file the appeals. Now the appellate authority or the statutory authority to decide proceeded on the premise that since the second writ petition is pending, therefore, Honorable High Court is in session of the matter. I should not decide the matter. Whatever appeals are there, we should not decide. Therefore, it's my lordship.
We will take it from now.
One, my lord.
You are on page 97.
My lord.
You are at page 97 interpreting that.
97 is the communication to me about the incidents which are developed against me. I move in appeal. Now,
No, but what is your stand of the service of notice otherwise by hanging in at your residence?
we have not filed affidavits on that either because the Honorable Court of the view that I would have explained my stand. It may not go that doctrine of non-traverse minor. I would definitely meet that. But so far as the first, in the motion stage itself, we are still there, minor. Therefore, I may not be able to explain much on that. But the fact remains that I was not aware of the proceedings against me, the culmination of the results and the communication of it. 3 parts to it. I was holding the chair. It's not that I had debated office. I was holding the chair. It is only after this I did not touch anything. But this is by the record. They also would agree to that. That I was continuing. It's not that I was not continuing. It's only after this that I did not. Might have been because the writ petition was pending here. The validity of 29/9/2023 AGM was pending. So therefore, no one thought it proper to say, but the authorities intervened and issued the communication to me, which I respected and I challenged, put in challenge. Now, if my lord takes up the third writ petition for a moment.
Yes.
In this writ petition, page 13. One three. This writ petition was filed because the registrar was silent on two aspects. One, 39, the approval being granted. I never received a copy of that. Approval being granted. And the other one, the induction of the chairman Shodhanshu on 39 itself.
Oh, just a moment. When we are in this third writ petition, look at this order. Daniel.
In the third writ petition.
Also. No, the first order, the first page order, second page. First paragraph.
Absolutely. That was why in the motion stage it said, because these questions never came across.
No, you said about, I'm referring to
No,
you.
some query will refer on the factual part. On the legal part, I can submit it. On the factual part, I need to file an affidavit if need be. But I'm not on that at the moment. Lordship may hold it. No, may not. Page 13. Yes, it was there. It was on record. It was on record. Page 13. Again to them.
Yes. Yes.
My lord. If I may read, my lord.
This proceedings is AGM.
AGM. Yeah. In context of subject as aforesaid, you hereby informed that the proceedings which were submitted on 29/9/2023 were examined. And it has been found that notice issued for convening a meeting was signed by Sri Sanjay Das as secretary. And as presently, can we appreciate the way, the manner it fell through, was signed by Sanjay Das as secretary. And as presently Sri Sanjay Das is not the secretary, therefore, approval to the proceedings of 29/9/2023 cannot be granted, my lordships. Had this stand been one second.
Yes.
My lord, My lordships. Notices for election for AGM. In common parlance, AGM election is written that way. It's AGM. Are issued by the authorities, of which one is the secretary and the chairman. Now, an AGM is sought to be held bad in law because the secretary who had signed as secretary was not the secretary when the time came for approving the resolution. This, the way it has been appreciated, is contrary to law. It could have been, you were not the secretary then, therefore your notice is bad in law, therefore the proceedings are also vitiated. Resultantly, no approval is granted. But that was not what the authorities had said. In no uncertain terms, they said, it has been found that the notice issued for convening a meeting was signed by Sri Sanjay Das as the secretary and as presently. It's a quantum leap, my lord. It was signed by him, but now since you are not the secretary, therefore approval cannot be granted. There is a precise case for consideration in the second writ petition. The second writ petition is on this, which is the first in point of time, that because by that they cannot elaborate on affidavit any other thing to show this beyond the reasons shown here, because that's the only reason they had. That Sanjay Das, as presently is not the secretary, therefore his signing then is bad in law. Anyways, that's for the consideration. Now it leads us to the second part. What were the notices? What were the signatures? That in the third writ petition, page 50 and 54. Second, no, third. Second writ petition, second, third. Page 48 first.
Appropriate English word in this matter would be pot boiler. The dictionary says meaning of pot boiler is a book, film, or other creative work produced solely to make originator a living by catering to popular taste.
It ends in a cliffhanger, my lord. I put it that way, it's a cliffhanger. In reference to that pot boiler. Anyways, now the authorities officially, nothing wrong in that, ask the chairman /48, page 48, the vice chairman / secretary, that you hold the meeting. This is on 1st of September. Convening of board of directors meeting. Now notices are issued, page 49. I would refer to page 50, the vernacular. My lordships. Page 50, lordship is there. Top left, Sabhapati. H3 is blank. My lord, this is dated 1st of September. This is issued by Vikas Das. On 1st of September, Ranjit Das was the chairman. This notice ought to have had his name. All muscle power, if I put it that way. Will not even put your name. The register recognizes you, we do not recognize you. You're going for 19, we simultaneously go for 39, 29, 9 and 39. That's how it happened. So this is how notice is issued. The name of the secretary is blank. President is blank. Manina so and so. বিদিত সন্মান সহকাৰে আপোনাক জনাও যে অহা ইংৰাজী তাৰিখ 7/9/2023 দিনৰ 11 বজাত সমিতিৰ দীঘলতৰাঙত থকা অস্থায়ী কাৰ্যালয়ৰ সঞ্চালক মণ্ডলীৰ এখন বৈঠক অনুষ্ঠিত হ'ব। My lord, that's how they proceed. I move on to page 51. That's the notice issued by us. 52 is the vernacular. I refer to the vernacular ones only. 52. This is the notice which has reference to the rejection order, my lord. This is the notice. May I read? 2nd of September 2023. On the top, lordship finds Sabhapati Sri Ranjit Das and Hampadak Sri Sanjay Das. As on 2/9, undisputed. As on 2/9, Sanjay Das is the secretary. 29/9 he is removed. And Ranjit Das is the president because 30th of August he is brought in. Even prior to that also, he was declared valid. And prior to that, Honorable Court stayed his removal. But Vikas Das chose not to recognize him as the president or the chairman. Now this is 2/9. It says, Yadora Debut Dangore River Part 1 Mean Hawai Committee Limited. সঞ্চালক মণ্ডলীৰ সকলো সদস্যক জনোৱা হয় যে অহা ইংৰাজী 7/9/2023 তাৰিখে নিম্নলিখিত স্থান সময়ৰ কাৰ্যসূচীৰ সমিতিৰ সঞ্চালক মণ্ডলীৰ এখন সভা আহ্বান কৰা হৈছে। গতিকে সকলো সকলে সমিতিৰ উক্ত সঞ্চালক মণ্ডলীৰ সভাত উপস্থিত হৈ থাকে সভাখন সফলিত মণ্ডল কৰিবলৈ অনুৰোধ কৰা হ'ল। So this is issued by both chairman and secretary, signed by secretary. Pausing for a moment, my lord. Pausing for a moment, my lord. This issuance of the notice was held to be bad in law because this notice is 2/9/2023. As because on 29/9/2023, Sanjay's Vikas's removal was interfered with. Therefore, this notice was held to be bad in law, and therefore the entire election proceedings were vitiated. Assuming for a moment, Lordship, for a moment, holds this view to be correct. For a moment, Lordship holds this view to be correct. Two things I must address then. Number one, the issuance of the notice by Vikas Das, who although was not then but was approved later, without the consent and approval of the chairman, whom the registrar has declared to be the chairman, whom the Honorable High Court has interfered to the extent that this is not the way you do things, not the way to remove a man. That also stands vitiated. Number one. Resultantly, they ought to have been a fresh AG. Not that they could have proceeded and reached on 30th. If this is vitiated, 29/9 is vitiated, for the only reason that Sanjay could not have signed then, although he never knew what would be the outcome on 39. Now, my lord, 2/9/2023 is prior in point of time to Justice Sham's order, which is 20th of September 2023. As on 2/9/2023 is only after Justice Barua's order, 25/7, which interferes to the extent that this is not the way. 49/2L, you cannot exercise the power. This is bad. However, did not adjudicate on that because it was on different count also whatsoever. So at that point of time, if I go back and think like a common man, as Sanjay or as any person of that society, the judicial orders in hand are 25(7), which openly says that these are bad in law. The way the Bikash removal was interfered with is bad in law. So therefore, Sanjay stands. Sanjay would also understand in that way, or any person would understand in that way. And on 2/9, the notice is issued because the ARCS has asked us to issue notice. That is why the notice was issued. And it was co-signed by the chairman, who is the chairman because on 30th of September, August, he was declared to be the chairman. Now comes few days down the line, when the the AGM proceedings are midway, my lord. Kindly appreciate this fact. This is our hat note 2023 7/9 till 7/9. Only Justice Barua's order is there. Justice Sham's order has not yet come. So we know that this is bad. So I'm continuing. So I signed. He issues or not is not my lookout. I have the approval of the chairman. He doesn't have the approval of the chairman. On 14/9, 7, it could not be held. On 14/9, page 54. I'm deliberately referring to the vernacular part, Miller, without going to the English translations.
Page,
54.
yes.
This is signed by Ranjit Das and Sanjay Das. As on 14/9, Sanjay continues. ইয়াৰ দ্বাৰা ডিব্ৰুডাঙৰি ৰিভাৰ পাৰ্ট 1 মীন সমবায় সমিতি নিৰ্মিত সকলো অংশীদাৰসকলক জনোৱা হয় যে সমিতি 2023-24 বৰ্ষৰ বছৰেকীয়া সাধাৰণ সভাখন উল্লেখিত কাৰ্যসূচী স্থান তাৰিখ সময়ত অনুষ্ঠিত হ'ব। Down below, Lordship finds সভাৰ স্থান দীঘলথৰং বস্তি শ্ৰী শ্ৰী ৰাধা গোবিন্দ মন্দিৰৰ প্ৰাংগণ, সভাৰ তাৰিখ 29/9/2023, সভাৰ সময় দিনৰ 11 বজাত। As on 14/9/2023, on 14/9/2023, fixing out on 29/9/2023 is not against or for the interest of all. It's a routine procedural matter. Sanjay had signed along with the secretary, along with the chairman. Now, since difficulties by to support my it led to the filing of WBC 5512. And the central controversy was what is to be done. And therefore, it was submitted that the AGM is on 29/9/2023. And it was a consent order. Bikash was there in that inter party order, a consent order. Yes, adhesion needs to be taken. And it was so taken on 29/9. But on 29/9/2023, two things happened. One, the registrar in Guwahati was taking a call. It was the other officer at the jurisdictional place was taking a call who should be the secretary. It had nothing to do with the issuance of the notices by any point of time. If at all, it was presently who should continue to function as a secretary. That was all it was there. Because this was an AGM, not an election. It was declared that here that Bikash would be the secretary. And no one objected to it. In all fairness, because a lot of difficulties where everybody wanted things to settle down. And Ranjit also did not object to that. The other 29. He did not even know that 25th this was a meeting to remove him, he was removed. Had it been known in the realm of writ petitions being filed and appeals being filed and hearings being conducted before the authorities, this point would have come up. They were tight-lipped about it. That was what I'm heading on. They were tight-lipped until we received this registered post that we could know what things were. So on 29th of September, in the AGM, resolutions were adopted. Because, may I put that question to myself, why the resolutions were adopted? It was so because the authorities had permitted us to go ahead with the AGM. Prior to holding of the AGM, there was not a whisper, no shred of doubt expressed that Sanjay ought not to have signed. Parallelly, they had not yet expressed any concern that the notice issued by Bikash is vitiated ex facie because he does not have the approval of the chairman.
After 14/9, what was the proceedings between?
Yes.
Hmm.
I appreciate Milord. I was absolutely referring to that. After 14/9, AGM was held on 29/9, but on 15/9, we submitted a letter to the Registrar of Cooperative Societies at page 55. I refer to only page 57. No, page 58 only. 55 we submitted to the registrar, as received on 15/9, Milord. After 14, the next day we submitted this letter. This has a backdrop of how the things develop.
Yes.
Paragraph 12 at page 58. This is where we tell the registrar that legal consequences would be fatal for the board. Paragraph 12, the narration I leave, Milord. Paragraph 12, if I may read at page 58.
Yes.
That in such facts and circumstances, it is prayed that no approval be granted to the meeting illegally convened at behest of Vikas Das on 14/9/2023, which does not has the approval of the chairman, the undersigned, and or the vice chairman of the society. Approval, if so granted in the interregnum to the meeting illegally convened at the behest of Vikas Das on 14/9/2023 be cancelled. Otherwise, it may attract the provisions of section 39 of the Act, and the board of directors of the society shall stand dissolved. There cannot be two AGMs. We're trying to say that. They also held, fixed the date on 30th of September, ours on 14th, but ours on 29th. On 14th, since we could come to know this is happening, we thought it is fair enough to tell the registrar, kindly intervene. Otherwise, things would go wrong. They did not intervene. But the meeting was held on 29th because this honorable court also noticed that it was inter-party and consenting order that 29 AGM is to be held. We held the AGM on 29th, and we did not object that secretary would be the Vikas. It was accepted that his removal was bad in law. It was accepted that 29 AGM is correct in law. There was a delay in holding the AGMs. The delay because there was a lot of chaos, politics going on between the same members of the board, and people were taking wrong sides. Wrong each for the other, wrong sides. And if they traveled so far, that was my smile had nothing to do with the case. It was just a reflex action. Anyways, but they did not say that 29/9 was bad in law. You should not have held it. At 59, page 59, which says Sanjay is not the chairman now, therefore it is bad in law. In this facts and circumstances, I sum it up to say that who should be the chairman has been decided by the registrar on 30th of August 2023. What has the page number? If we are on one page at that, we travel a little bit further. Therefore, the issuance of the notices by the chairman along with the secretary is to be held valid because it is the approval of the chairman who was declared to be correct one on 30th of August. And so far as Sanjay is concerned, his induction was not interfered with.
You're saying that this page 40 order of 38,
38/2023.
it restores your position as
Not
chairman.
only restores, declares. It was still then because by Justice Barua's order, there was under a stay. My removal was stayed. I was never removed. Only it validates that, yes, your removal was valid. I was never officially removed. I continued. First the removal, then the stay by this honorable court.
So now you are projecting that the notice could not have been issued
Should
without
be,
your approval.
that is the law. Any notice issued by secretary must have the approval of the chairman. The chairman can also issue a notice. I issued a notice, but it was co-signed by the secretary. Lordship, the date is 0209. As on 0209, the controversy was not resolved. Rather, on 25th of July, this honorable court had opinionated in no difficult terms that so far as Bikash is concerned, his removal being interfered by the authorities is bad in law, is not warranted in law. So that proposition remained through 2-9. It remained through 14-9. It remained through 15-9 when we informed the registrar. It was only on 29-9 that when the jurisdictional authority decided the matter, because on 20th of September, this honorable court says 29-9 is the AGM, can we decide who should be the secretary? It has nothing to do with the issuance of notice, but that who should continue as the secretary. So therefore, the issuance of notice by Sanjay Das as secretary and by Ranjit Das as chairman is not vitiated in any view of the matter. More particularly because of the judicial pronouncements following in places. 25-7, prior then 38, Ranjit is intact, 25-7, all things done that both are there. The controversy continues. So therefore, Sanjay could have signed. Since there was a controversy, if I may say so, if I put it that way, and there was no express adjudication, if I may still put it that way, taking his side also, then when Bikash issued the notice, that ought to have had the approval of the chairman or something to the registrar to say that the chairman is not approving my notice. Either way, or the vice chairman is not approving the notice. It must be approved by someone. If someone is not approving, I must approach the jurisdictional authority to say so. Or I may concede defeat. I may acquiesce. In an act of acquiescence, I may say, all right, you're not conceding, I will not challenge that. But still, unilaterally, I proceed to march to hold an AGM with my members of my team. Therefore, Ranjit, Sabhapati, that part is blank. The list we expect from a secretary is that he brings it to the notice of the authorities that the chairman is not cooperating. That was not done. In an act of acquiescence and in an act of unilateral display of behavior, he issues a notice. Whether or not it's good or bad is something else, but he alone could not have issued a notice. And the 29-9-2023 AGM is conceded by all parties. Bikash Das was there, he also concedes. 5512. The AGM is on 29. The day prior to that, it has to be decided. I paused for a moment and I put it to myself. Was it not the bounden duty of Sri Bikash Das to apprise the court that no, parallelly we are also going ahead and holding on 30th?
Yes.
So therefore, so far as the second writ petition is concerned, it is only that rightly the chairman had issued the notice and issuance signature by Sanjay at that point of time was not bad. And this is not their stand that it was bad then. They say, now you are not the secretary, therefore that notice is bad in law. That is far-fetched. So the 29-9 AGM I leave it to your lordship. End result would be it stays or it does not stay. Now, if it stays, then there is no 39-2023. There is no removal, no appeal, no review, nothing, everything goes. But if it does not stay, my respectful submission is, even then, there cannot be a 39-2023 because the notice did not have the signature of the chairman or the vice chairman. Unilateral act cannot stand. And there must be one AGM because it needs a prior notice, prior thing. So the members at large know which meeting to attend. There can't be 2-3 simultaneous meetings going on, my lord, notices to come, because the members at large will do the same. You come here, come here, come here. That entire thing is bad. The point is, was it at any point of time reported to the authorities that something wrong is going on? The answer is yes. We did so on 15/9. This is not the way it functions. It can have a cascading effect on the existence of the board if 39 comes in. So if 29/9 AGM is held to be bad in law, then the board goes. There has to be a new AGM from new board has to come. And if 29/9 AGM is held to be good in law, everything goes. Nothing else remains. But the registrar concerned, he has not appreciated the matter in entirety, if I may say so. And in bits and parts, appreciated facts to suit either parties. Some part would suit me, some part would suit him. That is not the point. We wanted an adjudication. The presence of 2 chairmen now and the presence of 2 secretaries then has created this chaos. There should be 1 chairman, 1 secretary. That's all I'm saying. Now, another part remains, which is my removal. My removal as the chairman. On 25/9/2023, when I was removed as a chairman, Vikas Das was not officially declared to be the secretary. Therefore, his act lets us, it's more than what it meets to the eye. The interpersonal vengeance takes a toll further because 25/9, he was not the secretary, he was declared on 29/9. So all these things brought in, and 39, a new chairman is brought in, Sudhanshu. Okay, that's all. That's all. No.
Yeah, please. Slight difficulty has cropped up, your lordship, slight handicap has cropped up, your lordship. So, I mean, I am there in item number 2, your lordship, the standing council. And my learned friend, Mr. Bodlo, he is in item number 1. And in item number 3, my learned friend, Miss M. Bora is there. And in the earlier matter, your lordship, Justice Borua had passed the order, your lordship. Our senior standing counsel, Mr. S.K. Talabdar, was present. Now, the issue is that I am confined to your lordship, item number 2, your lordship. But there is a linkage, your lordship, as you must have noticed, your lordship, that it starts from the first writ petition itself. Order passed by Justice Borua, and thereafter passed by Justice Shyam, your lordship. And then these 3 matters which have cropped up, your lordship. If I may pray, your lordship, the lordship heard the matter substantially, your lordship. If your lordship, your
That prayer is 2 hours 45 minutes late.
lordship, I did not wanted to interfere in that.
No, but
So
you see,
yes.
that can't be permitted.
Lordship,
Having spent time,
lordship,
the idea is to spend time profitably.
lordship. Then I will
Because
submit in regard to
If
item
it
number,
is adjourned,
lordship.
then we already said that there is water in the fish. The fish can travel anywhere
Lordship.
if it is water.
I was only wondering if one council could have submitted after going
No,
through it
it's
in a
better.
short- so,
Three people are, 3 is better than 1.
Lordship,
We'll have more wisdom
Lordship, then I may submit
Hmm.
in item number 2, your Lordship,
Yes.
WBC 6243.
6 to
6243, 2023, item number 2. Wherein the letter of the ARCS, which is at page number 59, your Lordship.
just
Yes,
6243.
6243. Item number 2.
yes.
In this matter, your Lordship, page number 59 is the impugned letter of the ARCS dated 7/10/23.
At forgotten, Mr. Rajkumar.
Yes, your Lordship. V. Raj.
Yes.
Yes, your Lordship. In this writ petition, your Lordship, the communication dated 7/10/2023, that is at page number 59, that has been challenged, your Lordship. If I may just read. This is from the ARCS Tinsukia to Sanjay Das regarding the proceedings of the society dated 29/09/2023. In context to the subject as aforesaid, you are hereby informed that the proceedings which were submitted on 29/9/23 were examined, and it has been found that a notice issued for convening a meeting was signed by C. Sanjay Das as secretary, and as presently C. Sanjay Das is not the secretary, therefore the approval of the proceedings dated 29/9/2023 cannot be granted. Now, your Lordship will kindly, we have filed an affidavit in opposition dated 23/11/2023
Yes.
in the instant matter, your Lordship.
Yes.
Earlier, your Lordship, the dispute regarding to the secretary, a writ petition was filed, that is WPC 5512/2023. And an order was passed, your Lordship, dated 29/2023. That is at page number 71, your Lordship. The relevant portion is at page 72 of our affidavit in opposition.
You see, sum and substance
Yes, your Lordship.
of what you're projecting in your affidavit in
Yes,
opposition
yes.
practically supports Mr. Banik.
There is a letter which I would like to highlight, your Lordship.
Because here in your in page 69,
Yes, your Lordship.
you admit that that Ranjit Das was unlawfully removed. If that be so, then the notice convening this AGM couldn't have been issued without signature of the Ranjit Das. That fortifies
Yes, there is a
stand
letter.
of Mr. Manik. And practically non-suits the question Mr. Karita.
I will highlight the facts, your Lordship. I'll highlight the facts. At page 72, your Lordship, an order was passed on 29/2023. The second para, your Lordship, the central controversy involved in this writ petition pertains to the question of legitimacy of either the writ petitioner or the respondent number 6 to continue in the office of the secretary of the Dibru Dangari River Part 1 Means Samavaya Samiti Limited. It appears that by resolution number 1 adopted in the meeting of the SS Limited held on 16/6/2023, the respondent number 6 was removed from the post of secretary of the committee. And as per resolution number 3 adopted in the said meeting, the writ petitioner herein was appointed as the secretary of the committee. Consequently, the petitioner has taken over and continued to function as the secretary of the SS Limited. However, the Assistant Registrar of Cooperative Society Tinsukia, the respondent number 4 herein, had passed order dated 27/6/23, suspending the approval of resolution number 1 of the Board of Creditors of the SS Limited adopted in the meeting dated 16/6/2023, as a result of which the respondent number 6 was restored back in office of secretary. When the above position was obtaining, the learned single judge of this court had passed judgment and order dated 25/7/2023 in WPC number 4083/2023, which was instituted by the present petitioner and two others, thereby observing that the order dated 27/6/2023 passed by the respondent number 4 was without the authority of law. However, it appears that since the subject matter of the said writ petition was pertaining to the question of validity of the resolution adopted in the board meeting dated 5/7/2023, the learned single judge did not pass any effective order interfering with the order dated 27/6/2023 issued by respondent number 4, Your Lordship. There was no interference. Today, when the matter is called up, Mr. Banik, learned counsel for a writ petition submitted as so as to end the uncertainty in the matter. The best recourse for this court would be to direct the respondent number 2, that is the Register of Cooperative Society, to decide on the question of legitimacy of the petitioner, vis-a-vis the respondent number 6 to continue in the office of the Secretary of the Society. Since the AGM of the society is scheduled on 29/9/2023, Mr. Banik submit an attempt may be made to decide on the said issue prior to the holding of the AGM. Mr. So-and-so learned standing counsel proposed this department as well as Mr. Haq, learned counsel for respondent 6 have also fairly agreed to such a request. In view of the above, without commenting on the merit of the claims and counterclaims of the parties, this writ petition stands disposed of with the consent of the parties by directing the respondent number 2 to decide on the question of legitimacy of the writ petitioner vis-a-vis the respondent number 6 to continue to function as the secretary of the board. The decision may be rendered either by the respondent number 2 himself or through any other competent officer authorized by him on that behalf. So the court had directed any other officer may be authorized, Your Lordship. Accordingly, the ARCS conducted hearing, Your Lordship, on 28/9 and on 29/9, and that hearing report, Your Lordship, is at page number 30 of the writ petition, Your Lordship. 6243. Page number 30, Your Lordship, of the writ petition. May I read?
Yes.
As per the Honorable Guwahati High Court, WPC number 5512/2023, Sanjay Das versus the State of Assam and others, and WPC number 5526/2023, Ranjit Das versus State of Assam and others, and letter from the RC of Assam, wide number so and so, dated 22nd September 2023, a hearing was held in the office of the Assistant Registrar of Cooperative Society, Tinsukia. At the time of hearing, total 12 numbers of BOD members of the Dibru Dangari River Part 1 Samarbai Samiti was present, namely so and so. In the hearing, the following observations were made, Your Lordship. This is important. Number 1, whether or not the members received invitation letter for the Board of Directors meeting, which was held on 16/6/2023, where the proposal of removal of Vikas Das and appointment of Sanjay Das as Secretary of Society was discussed. Answer: 9 number of BOD members claimed that they had not received any invitation letter for meeting held on 16/6/2023. However, 3 numbers of BOD members claimed that they have received the invitation letter for the said meeting. So controversy starts from 16/6 itself, Your Lordship, in regard to resolution 1 and resolution number 3, Your Lordship. Number 2, whether or not the members were present in a meeting held on 16/6/2023. Answer: 10 number of members were not present in the meeting. Also, 3 number of members claim that Ranjit Das, chairman, and Pramod Das took signatures from them on 13/6/2023 at 7 p.m. on a blank paper of the register, as claimed by the 3 members, citing that it was regarding shifting the residence of the society. These BOD members have claimed that their signatures have been misused. According to them, they were misguided by Ranjit Das, which is why they filed a complaint petition against the meeting held on dated 16/6/2023, as the said meeting was not actually held. Number 3, whether or not the members agree with the anomaly charges brought against Vikas Das at the BOD meeting held on 16/6/2023. 8 numbers of BOD members told they believe Vikas Das had not done any anomaly and is paying the KISS dues regularly. Whereas 4 numbers of BOD members believe that the Vikas Das is involved in anomaly activities. Lordship will kindly come to number 8, Your Lordship.
You continue to,
Paste,
we'll
right.
continue to.
Lordship.
Would also please make a mention of item 24. Please button up your coat first. Because item 24 matter is listed for hearing lot, because board is really heavy. Make the adjournment in the matter lot. You ask someone to make a mention, because we can't permit mention at any time.
अरे तो day-long program होगा जब लगे से day-long program होगा.
Hearing matter, my lord, item number 14. I have been requested to
Ask somebody to be here.
some accommodation, my lord, I was requested yesterday to
Ask somebody to be here.
oblige.
Otherwise, it will be very, whatever it will become inconvenient for the court to.
I
will
appreciate.
mention-
I need a little time to
No,
prepare.
it's okay. Just ask somebody to be here with accommodate.
Oblige.
Yes, you are at page 30.
Got it. Page 31, Your Lordship.
Hmm.
Serial number 8. What is Ranjit Das chairman version about the removal of Vikas Das and proposal of Sanjay Das as secretary in the BOD meeting held on 16/6/2023? Answer: Ranjit Das has submitted some documents regarding the said meeting and close herewith, but he
Just
could
a
not.
moment.
Yes, sir.
You are in WBC?
6243.
6243. Oh,
6243. But he could not.
yes.
Ranjit Das has submitted some documents regarding the said meeting and close herewith, but he could not provide any show cause notification in Vikas Das' name issued before the BOD meeting held on 16/6/2023 and proving the anomalies done by him. Hence, on the basis of the following section of the Assam Cooperative Society Act 2007, Vikas Das is supposed to be the legitimate secretary of the society. 1. The meeting said to have been conducted on 16/6/23 was organized at the residence of Ranjit Das, president of the society, despite the fact the society has a permanent establishment where the proceedings could have been held. 2. As per section 43 within bracket 8, the state government and registrar may appoint nominee to the board or any subcommittee of a cooperative society on its own motion when government has subscribed more than 50% of the paid up share capital or when there is provision of government nominee in its bylaws. The society, however, did not notify the office of ARCS Tinsukia about the meeting ahead of time. Also, the society did not submit an official invitation for a government nominee to be present during the proceedings of the said meeting to the concerned authority in the office of the ARCS Tinsukia beforehand, whereas government has above 50% share capital in that society. Then you also, the meeting held on 16/6/23, where Sanjay Das was selected as the CEO Public Secretary, was not in accordance with section 3812 of the Assam Cooperative Societies Act 2007, because the society has not notified any notification about appointment of the CEO of the society, secretary of the society before the selection of secretary of the society. Therefore, on the basis of the written statement given by all the 12 number of members present during the hearing, it can be concluded that 8 numbers of BOD members have expressed their desire to have Vikas Das as the secretary of the society, 3 numbers of BOD members have expressed their desire to have Sanjay Das as the secretary of the society, and 1 number of BOD member has decided to not choose any side. Also, on the basis of the above mentioned reasons regarding the non-compliance on the part of the society with the rules and regulations mentioned in the Assam Cooperative Societies Act 2007, it can be concluded that BOD adopted the resolution of removal of Vikas Das from the post of secretary of the society without any so-called notice of his guilty before his removal. My opinion, it is arise from the above that the termination of Vikas Das as secretary and subsequent appointment of Sanjay Das as the secretary of society may be deemed as illegal. In view of the facts and statements made by majority of the BODs, the undersigned has come to the conclusion that Sri Vikas Das is the present legal secretary of the society, which was dated 29/9/2023. This is the report, Your Lordship, subsequent to the order of this Honorable Court. Lordship, I will just quickly take Your Lordship to our affidavit in opposition, Your Lordship. At page number 65, para 4, if I may read, Your Lordship. That as regard the averment made in paragraph 2, petitioner has stated that while resolution number 1 was suspended, resolution number 3 was not interfered with. However, the petitioner has failed to realize that resolution number 3 is subsequent to resolution number 1 and both are consequential in nature. That is, upon suspension of resolution number 1, which removed Vikas Das as the secretary, the subsequent resolution number 3 appointing Sanjay Das as secretary cannot be given effect to, as only one appointment can be made against the said post of secretary. The deponent would further like to highlight the chronology of events, which is as follows. Your Lordship, the 16/6/23, Your Lordship, that has been subsequently, the report has highlighted, was not done, it was illegal in 29/9/2023. And on 27/6/2023, an order was passed by the ARCS Tinsukia, and resolution number 1 was suspended. Thereafter, on 3/7/23, Ranjit Das filed an FIR against Vikas Das. Therefore, on 4/7/23, ARCS Tinsukia passed an order withdrawing the order on 27/6. And thereafter, on 5/7/23, the Zonal Register of Cooperative Society, he vacated the order of 4/7/23 for 3 days, for 10 days, and 3 days time was given to submit evidence of FIR. As no FIR was submitted, Your Lordship, on 14/7/23, the order dated 4/7/2020 was permanently vacated instead of 10 days in view of failure to furnish the required information. That we have annexed, Your Lordship, at page 75, Your Lordship. This order was passed by the Zonal Register of Cooperative Society on 14/7/2023 itself at page 75. Then Your Lordship will kindly come to page 76, Annexure C. An order was passed by the Register of Cooperative Society.
Where is this 4/7/23? Where is that?
That is at page number 75 or for affidavit in opposition, Annexure B. The relevant portion is at the last para. Further, in view of the failure to furnish of the required information, the earlier of the order of the Assistant Registrar of Cooperative Societies, Tinsukia, issued by letter number so-and-so dated 4/7/2023 has been permanently vacated hereby instead of 10 days. So this was vacated, Your Lordship. Lordship will kindly turn to page 76, Annexure C. There was another writ petition was filed, which is mentioned in this order of the RCS, Your Lordship. Peruse the Honorable Guwahati High Court order dated 4/8/2023 in WPC number 4414/2023. Also peruse the appeal petition dated 26/6/2023 submitted by Sri Nityalal Das, fixed the date of hearing on 29/8/2023. The following persons attended the hearing: the Assistant Registrar of Cooperative Society, Tinsukia, Ranjit Das, President of the Society, and Vikas Das, Secretary of the Society. See, Nityalal Das, petitioner of the society. So in this case, Your Lordship, what has happened? Nityalal Das had not, in WPC 4414/2023, he did not attend the meetings, Your Lordship, for 3 consecutive occasions, Your Lordship. So thereafter, he was removed. So RCR has passed the order subsequent to a direction of this honorable court. And there also Vikas Das was considered as the secretary, your lordship. This, so earlier letter of the zonal register of cooperative society, page 75 and 73, these were not challenged. But subsequently, the petitioner had come before this honorable court. And after the direction of the honorable court, the status report was submitted, your lordship. Now at page 77, your lordship. This is the agenda of the meeting of 14/9/2023, Annexure D, page 77. This is in regard to conduct of annual general meeting for the year 2023-24. Page 77, serial number 4. Signatures of the members of Board of Directors who were present in the meeting. From 7, 8, 9, your lordship, there are 9 members are shown. 7, 8, 9, these are co-opted members, your lordship. Gopal Biswas co-opted, Raju Das co-opted, Alok Das co-opted member. If your lordship turn to page 78, the second paragraph, your lordship, here it is stated, in today's meeting, the secretary Sri Sanjay Das has informed that as the membership of 8 members are seized, therefore members posts in board of directors are vacant now. Also, as the board of directors has lack of quorum, so for the greater interest of the committee, such as for conducting or meeting of the committee, conduct of annual general meeting, etc., he requested to discuss the matter in the meeting and take decision for co-op 3 members in board of directors as mentioned under section 41 within bracket 9 of the Assam Cooperative Societies Act 2007. After detailed discussion of said matter in the meeting, the motion has accepted the proposal and support to co-opted of 3 qualified members for the board of directors unanimously. Now, your lordship, thereafter a letter was sent by the ARCS to Tinsukia on the same date to the president of the society, your lordship. That is at page number 87, Annexure E of our affidavit in opposition. Because lordship will note that there was 1 member was removed, Nitya Lal Das, your lordship. And so here the ARCS Tinsukia has written to the president of the society, reference detailed proceedings submitted on 14/9/23, signed by Sanjay Das. Sir, following comments are included for the above mentioned subject and reference of the meeting of Board of Directors of the Dibru Dangari River, Part 1, meaning Samabhai Samiti Limited, dated 14/1. Among the 9 number of directors who were present in the meeting, 3 members are as co-opted members. So, by order number so and so, dated 38/23, of the Register of Cooperative Society, there was only 1 vacancy for the post of director. But in the meeting of Board of Directors dated 14/9/23, 3 directors are selected as co-opted members for Board of Directors. There is no data available in this office regarding absence of said 2 members in 3 meetings of the society. So there was no material available, your lordship. Only 1 person was removed, your lordship. So they could not have taken the other the other 2 members for that meeting, your lordship. Number 2, as per document, lordship. Serial number 2, your lordship. As per the documents and data available in this office, there are no documentary evidence exists that Sanjay Das is currently working as secretary of so and so committee. So the Joint Register of Cooperative Society letter dated 14/7/23. The required action has asked to be taken by the order of Register of Cooperative Society Guwahati dated 38/2023. So the detailed proceeding dated 14/9/23 submitted by you is not accepted. So your 14/9, your lordship, the meeting that was not accepted, which has taken passed the resolution to conduct the AGM on 30th, your lordship. So if your 14/9, your lordship, board meeting fails, your lordship, then the 30th AGM also will go, your lordship, if your lordship consider that, your. So my humble submission, your lordship, that pertaining to the instant matter, your lordship, wherein they have challenged the ARCS letter dated 7/10/23, your lordship.
Just a minute.
Yes, yes.
Just a minute. You're saying that if the proceedings of 14-9
Yes,
goes,
yes.
then the corresponding AGM of
29/9,
29/9, that also-
29/9, yeah, that will go, your lordship, because they, if the co-opted members, they could have co-opted only one member, your lordship, one vacancy. So they could not have co-opted three members, your lordship. So that was not done properly, and which was communicated, your lordship, on 14/9 itself by the ARCS Tinsukia to the society, your lordship. So if that goes, your lordship, the 29 AGM also goes, your lordship. And on 29 itself, it was subsequent to the, in pursuance of this honorable court's order, your lordship, that the hearing was also conducted, and hearing report was also placed, your lordship, which held that the secretary is Vikas Das, your lordship. And the earlier communications also, your lordship, the secretary was Vikas Das, your lordship. That is my humble submission. I wanted to highlight. Obliged.
But what happens to the next part of his submission? But if the secretary, no, to Mr. Rajput.
Oh, sorry.
What about his second part of submission, that if the secretary remains as Vikas Das,
Lordship.
then the notice without concurrence of the chairman, would it be valid according to you?
Lordship, yeah, he had, the AGM that was, submitted by Vikas Das, your lordship.
No, so the notice convening meeting of AGM.
By Vikas Das. Your- He
on-
had,
On 39, whether that according to you is valid?
so he had submitted with the, that document, your lordship, is not before me, your lordship. And
That-
My lordship, what is
I'll have
happening,
to-
since there are three councils addressing the same
I am-
issue, they have, parts
No,
of.
no, I am asking a question.
Yes,
It's
yes,
a
yes,
question
yes.
of law.
Yes,
It's a question of law that this Vikas Das,
lordship.
he should this notice, which you will. I mean, 1975.
Vikas Das, your lordship, one council was implemented on last occasion, your lordship. That council,
This one, is 67. You show him that, Mr. Manik.
67.
That is clear in section 49, madam. That is, what you will find at section 49, madam. Whether madam secretary can issue notice.
No, not this. There's one more. Mr. Manik, show that letter, that notice. This one in. Convening the AGM at, convening the AGM on 30.
Executive notice, chairman, my, temporary approval of all, both of him came to conduct the particular person.
Take one. 19. This notice was given to the director, one of the directors of the board of directors.
The query of the court is that whether if
Whether
appointment of Vikas Das as secretary is valid,
valid,
whether notice
issued by because
issued by him
yes.
alone, that will stand the scrutiny of law.
right.
You take the time, you tell us, because that
Lordship.
is the query of the court to you.
Lordship, I will get
And,
back to
and
lordship.
there is a second query
Yes,
to all three of you.
yes.
This Mr. Kalita is referring to section 49.
49,
49 refers to a chief executive,
yes.
who according to you is the chief executive.
Lordship, the secretary CEO is the interchange, your lordship, as
Secretary.
secretary, your lordship,
Secretary is interchangeable with his chief executive.
CEO. Convening.
Where is
So
the-
it's
where is
49
the-
E, your lordship.
Huh?
Convening meetings of the general body of the cooperative
49
society.
E.
49 E, your lordship. Convening meetings of the general body of the cooperative society, the board and the executive committee, and other committees or subcommittees constituted under provision of the act and bylaws, and maintaining proper records for such meeting.
Is chairman defined? Chairman or president or vice chairman or vice president, is it defined?
Yes. President, vice president, and 36, your lordship. Page 34 of the act. Page 34 of the act.
Okay. But then, this. Yeah, please, just a minute. There are two things. Number one, definition clause 2L. It defines chief executive mention individual so and so. Then 2x is office bearer. Office bearer includes secretary. And then there's a provision for secretary.
Section 38 can define.
Just now, we'll come to you. Now the query is to give this standing council. Secretary is at secretary is also defined somewhere. The secretary is not defined.
No, your
Okay,
your lordship. Definition at 2L. Definition at 2L, chief executive, your lordship. Means the individual in paid or honorary capacity nominated or elected or appointed by the board from among members, directors or others in accordance with the bylaws of the society who shall perform such function and responsibilities and exercise such power as specified in the act, bylaws and assigned by the board.
okay. According to you, the signature can, the notice convening meeting can be made by
Made by the
secretary
secretary.
alone. Okay. Yes, Mr. Bogway.
Well, in response to that, I may add up because it
We'll come to you back.
Lordship.
Let this part be complete.
Otherwise, my bracket friend has already making submissions, your lordship. Now, I'm on item number 1, your lordship. Item number 1, they have challenged the impugn order, your lordship, that has been passed by the Register of Cooperative Societies. That is page number 111, your lordship.
Item one is WPC
WPC 1975,
75.
your lordship.
Yes.
Now, the last page, your lordships, page number 114, Annex 21, that is the order that has been passed by the Register of Cooperative Societies in the appeal that has been preferred by Ranjit Das, your lordship.
Yes.
Now, in this, if your lordship kindly take up page 114, if may I read your lordship. Peruse the appeal petition, heard both the parties and scrutinize all the relevant documents. It appears from the records that the management of the said society conveyed board of directors meeting on 25/9/2023 with miscellaneous agendas. As per provision under section 36(4) of the Assam Cooperative Societies Act 2007, the board may, by the resolution passed by 3/4 majority of the directors present and voting at the meeting held for the purpose, remove the president or vice president. Such meetings shall not be presided over by the president or vice president against whom such resolution is to be considered. In the BOD meeting held on so and so, several decisions were taken, including removal of President Ranjit Das, which is not as per provisions of section so and so of the Assam Cooperative Societies Act. In view of the above observation, I so and so, Register of Cooperative Society, do hereby cancel the proceeding dated so and so, as the procedure of removal of the president of the society was a violation of the Assam Cooperative Societies Act 2007, your lordship. Now, one aspect of the matter is that, your lordship, The petitioner has submitted that there are 8 members of board of directors who were present on that particular day. And they have unanimously taken the resolution to remove Ranjit Das. Now, here, as per the act, your lordship, 2/3 majority. Total, there were 14 members. So,
Read that act again. Doesn't
lordship,
say
that-
total. Doesn't say total. strength.
yes,
It says member present.
member present. Now,
So
Eight.
member present,
2/3 majority, your lordship, that will whether the 8 members will come or the 14 members needs to be present, your lordship.
no,
That
member
has to-
present means member present. It doesn't say member, out of so and so members, the legislature doesn't use a word, that, what you call, for nothing.
No.
You can't say that the word is unnecessarily incorporated in the statute. So therefore, when it says members present obviously means members in the meeting, doesn't say members alive.
No.
Then the quorum, it would have clarified
Yes,
for a meeting that the members present would include members alive. So supposing there is a director who is dead, let us presume
lordship.
that today the board meeting is at 11, at 10 o'clock a director dies. Then we only have the god of death, Yamdut, to be summoned and have his life restored back. That is not possible.
With that apart, your lordship kindly takes up page 69, your lordship, that is the meeting dated 25/9/2023.
69.
Yes, your lordship.
You see, with the Registrar of Cooperative Society, this is not the only case where there's a there's a gap between the members present and the members' strength
Lordship.
of directors. Have in any case you have taken a stand that members, this provision has to be read as if members present means members alive.
Lordship.
Have you taken the stand in any case?
No, your lordship. So far, as per my knowledge is concerned, it's-
No, not your knowledge, personal knowledge. We are speaking of Registrar of Cooperative Societies. Have they taken a stand in any of these disputes? Is not the case that this is the only first dispute which has landed in court.
there are several other.
Yes, sir. It has to be several other matters. Have you taken a stand? If it's a consistent stand, we can assume that the intent of registration is being interpreted by the doctor, by the authorities in a particular manner.
Don't think so, your lordship.
Yes, you are showing something else.
Page number 69, your lordship, that is the
69.
meeting dated 25/9/2023, whereby the resolution has been taken, that is resolution number 3, page 70. The removal of the president Ranjit Das, your lordship,
This is board.
board, yes. The board resolution, that resolution number 3. Now here, if your lordship see the secretary, it was signed by Vikas Das and it was approved by Sudhanshu Das. Now, whether Sudhanshu Das was the president at that point of time, that will be relevant, your lordship. Please take it. Subsequently, if your lordship kindly takes up page 75. That is the meeting dated 30/9/2023. Now here resolution number
Just
6.
a minute. Yes.
Now, if your lordship kindly takes up page 75, that is the meeting dated 39/2023, AGM, your lordship. Here, uh, 2 lines below, your lordship, signatures of the shareholders. Sudhanshu Das, he put his signature as one of the shareholders, your lordship. And the resolution number 6, it is a resolution whereby it has the today's meeting unanimously resolved to welcome the approval decision taken by the Board of Directors of the Committee in its meeting dated 25/9/2023 against the President of the Committee as per provision of the Assam Cooperative Societies Act 2007. It is also resolved by the General Meeting to authorize the Board of Directors to confiscate the shares of those shareholders. General Meeting observed that if necessary, legal action should be taken against those persons. Now, this has been approved by the ARCS, your lordship.
Yes.
Now, if your lordship kindly takes up page 97. May I read it, your lordship? With reference to the subject cited above, it is hereby informed that the executive meeting dated so and so 25/9/23 of so and so, the annual general meeting of the shareholders held on 39/2023, resolved to elect Sri Sudhanshu Das as the present president of the committee. Department has already accorded approval to the said resolution. Therefore, you are hereby requested to stay away from the responsibilities of the president of the committee as per bylaws of the committee and concerned provisions of the Assam Cooperative Societies Act. Otherwise, he will be held liable as per law. Now, your lordship, Sudhanshu Das came into as a president on 39/2023. And whereas the meeting dated 25/9/23, which has been even though signed by the secretary Vikas Das, but the approval was given by the Sudhanshu Das, your lordship. Whereas on 25/9, Sudhanshu Das was not the president of the State Society, your lordship. And subsequently, based on the appeal, your lordship, the Register of Cooperative Society has passed the order, your lordship. It is my humble submission.
Meet with your lordship. My lord, I'm appearing in item number 3, my lord. I'm concerned with this writ petition only. Lordship, may kindly have a look the writ petition number 2094, my lord. My lord, may kindly have a look the prayer portion of the writ petition, my lord, page 10.
Yes.
Lordship, the jurisdictional authorities to cancel, recall, or otherwise forbid from giving effect to the approval to the AGM dated 39/2023, Dibru Dangri so and so. And this is the only prayer of the writ petitioner, lordship. But the writ petitioner have not annex any documents regarding the minutes, whether what are the resolution taken by that board of directors meeting, lordship, they have not annexed anything, any documents. So my humble submission is that my lord may dismiss this petition because notice is yet to be issued in this matter, my lord. I'm concerned only that because of this technical reason, my lord may dismiss this petition. They have not annexed anything, my lord, to show what are the resolution taken in those meetings, my lord. Only prayer is that they have to not to adopt the resolution of 39/2023. But is the other ground I am not aware. My friend has already submitted before this honorable court. I'm concerned only this item number 3.
Yes.
My lord, oblige, my lord.
For the repetition number 1975.
Just a moment. Just Mrs. Bora. Para 12
Lordship,
of this repetition
my lord.
is that in this court proceedings, there is no whisper of 39/2023.
Lordship,
12 of the repetition.
lordship.
Para 13 says, if the AGM is not interfered with, the matter which is scrutiny in WPC 6243 for 2023. Would be rendered infructuous.
My lord. The item number 2 of this,
Okay.
item number 2, my lord. This
These are two grounds.
lordship. But we are not aware what were the decisions taken in this meeting because this minute is not annexed in my petition. I'm concerned with only this petition, my lord, because my honorable court yet to issue notice in this matter, my lord. In fact, this matter was taken up today only. An earlier occasion, this matter was not taken.
No, it was
The-
taken up. I
No,
agree, but
you have not submitted regarding this petition.
I agree with it. I agree.
No, no, my lord, we have
It's on record.
argued,
It's on-
we have argued only the other
Every time you don't
petitions,
have to jump up. You see,
my lord.
we'll send you this record.
Lordship,
We'll send you this record.
my lord.
That's it.
Lordship, the earlier order, my lord. Yes, I was present, my lord.
No, no, no. The two matters are taken up together
Yes, my lord.
and there are two orders, so therefore this is not moved, cannot be said. And that is why the court has fixed it for hearing
Lordship,
of all
For
the two
disposal of
matters
this
together. Out of which the court is conscious that one is in a motion column and one is in the admission column.
Who are in the motion column? Item 1 and 3.
One matter is in the admission column. Notice has already been issued. Therefore, when council said that that matter should be heard, it's taken up for hearing. The question of issuance of notice or no notice that goes for a Shiksha.
Because I'm submitting for the first time in
No,
this
that's
matter,
okay.
my lord.
That's okay.
The first day of hearing, my lord, the matter was listed before some other bench.
Whatever
That's why court has not taken up the matter.
we are aware of what is happening.
One, item number 1 and 3, my lord, no notice was issued. Only the item number 2 notice was issued, and my friend has filed affidavit also in this matter. That he have submitted from his affidavit, my lord.
Yes.
Obliged, my lord.
The, my lord, the
Yes, that's fine. Yes.
my learned friend, Mr. Bordeloi, has referred the resolution dated 25/9/23, wherein Sudhanshu Das, it is shown as signature approved by Sudhanshu Das. In fact, it is there is typographical error. I apologize. I have annexed the vernacular also. Lordship will find that page 74.
Of which
1975. Should have been Jiten Das. Actually, Jiten Das was selected for to preside over the meeting.
page,
Page, my learned friend referred page 69, meeting dated 25/9,
yes,
wherein the Ranjit Das was removed and another person, Sudhanshu Das, was appointed as president. Here, my lord, approval shown, signature Vikas Das, secretary, page 70, my lord.
69.
Page 70, my lord.
Page
Lord, you
70,
come to page
yes.
70, my lord. Signature below, my lord, that is Vikas Das, and it is shown as, my lord, approved by Sudhanshu Das.
Yes.
Actually, it should have been, my lord, Jiten Das, because, my lord, this meeting was presided over by Jiten Das. This is typographical error, my lord. I apologize, my lord. Lordship will find the vernacular I have annexed. Vernacular at page 74, my lord. Down below, my lord. Signature. Grihito Jiten Das.
But everything goes.
Well.
Everything goes. All said and done, you can't save this board. This board has to go. It is expressly illegal. The provisions in the Assam Cooperative Societies Act has otherwise been referred in the order of the Register of Cooperative Societies that assisted Register of Cooperative Societies. Subsequently, that the government being a 50% shareholder, they have not intimated whatever you're trying to do to the government. So, in fact, everything goes. You can't save the board. You can save the God, God save the king.
I read it when he was reading
Well.
kept silent for the time. It came
God
up.
save
now.
the king.
Well.
That is possible, but saving the board is not possible. You
Well.
can both go outside and shake hands. Very the same board now.
My lord, but I appreciate, my lord.
No, he's correct what he's saying that Jiten Das was there.
So that's okay.
But that's okay. That's
My lord,
perfect.
That's okay.
thing is that, my lord.
That's perfect.
Long and short of it, it is only after Mr. Raskar that
Yes.
things are clarified. Yes, Mr. ABP Hawk.
Vikas Das.
Hearing in item number 2.
But he had already taken that side, he should have been on this side. Anyways.
Accordingly, I am declared. My name has not been shown to the local accordingly I could not prepare in this case. Suddenly I informed. Sides, unconsciously change when you are in sleep. Sometimes you are left, sometimes you are right.
He is sitting this side accordingly.
In daytime, when you change
This
sides,
side.
that's why he is asking you.
Night time, I notice section 38, Lucius. Whether the approval
Item
of
two
the
is
chairman is
WPC.
required,
Item 2 is WPC.
item C is WPC 6243, Lucius.
623.
Whether the approval of the chairman is required or not, Lordship, kindly see section 38 of the Cooperative Society Act 2007, Lordship. 3810, Lordship.
Section
3810, Lordship.
3810.
10, Lordship. Power and function of the board, Lordship. The holding the
3810,
annual
yes.
general meeting is the approval of the board is required, not the chairman, Lordship. Accordingly, board also the already approved the meeting for 30th, Lordship, which is signed by the Vikas Das, Lordship. The approval of the board is required, Lordship, regarding hold the annual general meeting, not chairman, Lordship. He may be absent, Lordship, in any meeting, Lordship. Research, Lordship. Because thus 30th meeting is the appropriate meeting, accordingly, the RCS also approved the same, Lordship. This is my limited submission. Prior board meeting dated 14/9/2023 already approved, Lordship. Prior resolution number 6 to hold the annual general meeting. 9, board of members is present in this meeting. Accordingly, the annual general meeting is held on 13th September 2023, Lordship.
Where is that provision? This government 40% shareholder, if they have to be informed and there is a provision in this act. Hmm?
He's talking about the program of the board meeting.
No,
No. The government has to be informed of to send their nominee. There's a provision, specific provision here. Or 8, that is 43(8). Where is that order you were reading? Where there's a reference of not informing the government,
Page 31 of the
which petition?
624,
Page number
page number 31.
31.
That is the inquiry report, your lordship, subsequent order of this honorable court. The relevant portion, your lordship, at page 31, your lordship, it's serial number 8.
So even in that earlier board meeting, where resolution were taken for this notice to
The-
to hold the AGM, there also there is no reference to any government nominee being informed.
No.
So if you stand by your order of page 30, same consequence follows for AGM of 30, you can't save it.
Lordship. But here it is mentioned, your lordship, as per section 43A, the state government and the registrar may appoint nominee to the board or any subcommittee of a cooperative society on its own motion when the government has subscribed more than 50% of the paid up share capital or when there is provision of government nominee in its bylaws. The society, however, did not notify the office of ARS Tinsukia about the meeting ahead of time. So that is a,
So that is the only inquiry the registrar will have to make if they have given notice.
Yes.
For the purpose of giving notice to the government. If not, the board goes. We hold a new AGM.
Okay.
I come back to square one where I started. I stopped you by saying that you will be best suited for the elections.
Now I'll reflect and respond.
Uh-huh.
I'll reflect and respond.
You like to respond. Okay, yes.
One of the three writ petitions. All facts are known. Law positions discussed. Now, first, we'll start up with what the one my friend is representing. There is a straightway submission made. I'm not countering the submission. I'm addressing the issue. But there's a difference to that. That hearing part, I'm leaving that. That the minutes of the meeting or resolutions have not been annexed. Correct. Not been annexed. But I've pleaded so. That ought to have been pointed out. Very well. I can also point it out. Pointed out. Page 9. Paragraph 15.
WPC,
WPC 2094. 2094.
para
15. Page 9.
15.
15. Page 9.
Yes.
It is stated that Lordship is known.
Hmm.
It is stated that the petitioner has not been furnished with any copy of the approval granted.
We are
to the
reading where?
proceed- Page 15, AB, Lordship skips, then
AB,
paragraph 15,
yes.
AB, we skip. General state pleadings, no? We skip that for a moment.
Huh.
Then it is
Oh, it's
stated,
not been furnished.
not been furnished. I've stated that. It has not been furnished. And the point is, it is not in dispute that the resolutions were approved. We are not on what was the resolutions. what were resolved. We were on the approval so granted, number one. Whether approval could have been granted to 38. That's one. Anyways, now so far as coming to the other two issues canvassed. The first one would be co-opted members. Co-opted members. You could not have co-opted 3 while there was a vacancy for 1. I'm under instruction to submit that to their query we had responded that there were 3 vacancies and so we are co-opting 3. We have the soft copy, we may give a printout or we can pass it on. We got it. It was not a part of the pleadings, so I put a question across. That's number one. Number two, now a natural question would fall that if their ground for rejecting the approval to 29/9/2023 AGM is and only is that the signatory is now not the secretary, then yes, but now not the secretary. Then in law, I must respectfully submit, you're not permitted to elaborate with other reasons. Co-opted members, this, that, who are present, who are not present. Because that was not the ground for rejection. The ground for rejection was simpliciter. They cannot elaborate by affidavit what was not the ground taken then. Commissioner of Police Bombay, Mohinder Singh Gill, public orders publicly made. We are not on that. Because that is no. They're trying to elaborate. But in doing so, what I'm drawing the attention to, in doing so, they're abandoning their ground for rejection. The entire pleadings does not highlight the ground. Rather, it focuses on some grounds, other grounds than the ground taken. Therefore, their stand is vitiated on the face of it. But the known doctrines of law is vitiated. We have addressed it. Now, so far as the secretary part is concerned, who is the secretary? What are his powers vis-a-vis meetings to be held? I will address this from a very neutral standpoint. Director can be a secretary. Anyone in there, as per the section, can be a secretary, but it needs a sort of consensus. That consensus can be said, selection of a secretary is a simpler word. So prior to that, the board has to be there, and either one or from outside. But there can be also a secretary appointed by the government. In that case of the government, the procedure is different. So far, the in-house secretary is concerned, but both are the secretaries in one secretary. Now, once a secretary comes here, he has the power to do a lot of things. In case of a dispute with him by the board, it has to go to the registrar. 49(2)L comes into it. So therefore, we understand, although a secretary can be a member of the board, yet it's distinct and different. The board
Not can be, he is a member of the board, he is ex-officio member.
Absolutely. What I'm trying to say is that the board and the secretary, although being together, are distinct and different entities, because in a clash between them, the registrar has to take a call. Here is a case where notices were issued by 2 persons. One, the chairman, one calling himself to be the secretary, or let us say the secretary itself. In a given case, the secretary itself, because whether it requires the approval of the chairman. That was a question. Point is, the chairman represents the board, and the board issued a notice on 2/9. It does not require the approval of the secretary in any view of the matter. But any notice issued by a secretary, any notice requires approval by the board. It must require approval by the board because
Is there a judicial interpretation on that?
I'll come to that. The Lordship may lay down the law. There's no difficulty with that. I'm addressing your Lordship, trying to persuade my Lord on that. A secretary does not have free powers. These powers are limited by the Act. And so the Act recognizes the board and the secretary to be distinct and different. Here, convening and holding of meetings, as in the Panchayat Act, can be interchangeably used. Holding of a meeting, convening of a meeting. But it will be too far-fetched to say that a secretary can go ahead and hold a meeting. A secretary can issue a notice. A secretary can serve notice without the concurrence of the board. The board is a body, coterminous with the term, and the board is hit by 39. Secretary is not hit by 39. Secretary continues. That's the beauty of it. So therefore, the board has a power on the secretary's actions. Regardless of all the factual situations placed before your Lordship, regardless of whether Vikas or Sanjay is a secretary, regardless of who's the chairman, but the chairman was the chairman declared by the registrar on 30th of August. And the chairman had so issued a notice for AGM, which does not require secretary's concurrence. And on the face of it, the notice issued by the secretary, if I may call him a secretary, for convenience, alleged secretary or secretary, did not have the concurrence. It must require a concurrence, not the approval. Board does not approve his action. That will be ex post facto. It requires a concurrence. Yes, do it. We concur in mind, and so you exercise your power. For this reason, the Act has kept the things subtly different. May I invite my lord's attention to the Act? And I will read from section 49, conjunctly, section 38. I start with section 49. I would not read the entire, only the preface part of it, and then the relevant. There shall be, am I not there? 49. There shall be a chief executive by whatever designation called of every cooperative society to be appointed by the board or by the state government. Here comes in the existence of the board to be separate. He is appointed. In the event of appointment of the chief executive by the board, he shall be a full-time employee of the society. Directors are not employees, but he becomes an employee. Now, I leave these 2-3 paragraphs, my lord. The D, I'll refer to D. May I read D?
Yes.
Or C and D together. Where the state government stands guarantee for repayment, skip that, my lord. Notwithstanding anything contained in law, in force, or bylaws of the society, the chief executive appointed by the government shall have the full administrative control over employees of the society in all matters, including transfer, posting, disciplinary action. However, in case of dismissal of employees, approval of the board shall be necessary. Either ways, my lord, he has a control of the employees, not over decisions taken. By the government, we borrow it. Number 2, the chief executive shall be under the general superintendent's direction and control of the board and exercise the following powers and functions. It does not mean without the concurrence of the board, you can go ahead and do it. You are under the general superintendent's direction and control of the board. So here's where the case where the president issues a notice. Prior to that, he issues a notice, which is directly in conflict with the board. Secretary cannot exist in conflict with the board, and that means calling of AGMs. 2E gives a power to the secretary, and I must respectfully submit that it is there. He also has a jurisdiction for convening meetings of the general body of the cooperative society, the board, and the executive committee, and other committees or subcommittees constituted under provision of the Act and bylaws, and maintaining proper records of such meetings. So he has a power to convene the meeting. To say that he can act independently without the concurrence of the board would be overreaching the Act. Now, so far as 35 is concerned, 35 tells us what is a board, and 38 is powers and functions of the board. We'll come to 38. I invite my lord's attention to kindly to come to 38. May I read 38? The board shall discharge such functions, perform such duties, and exercise such powers as may be specified in the bylaws and in accordance with the terms, conditions, and procedure laid down therein. And in particular, the board shall have the following powers, functions, and duties. So board also has some powers separate from that of the chief executive. Here, 10, to hold AGM in stipulated time. So far as AGM is concerned, the peril is of the board. If they cannot hold it, the board goes. So therefore, it's a duty of the board to hold the AGM. So the notice which is to be sent, albeit the secretary can issue the notice, the chairman can also issue the notice, the concurrence of the board is required for that. Otherwise, the consequences will be far-fetched. In this context of the matter, even though what had fallen from your lordship earlier, just thinking aloud, that if removal of Vikash is interfered with, if removal of Vikash is interfered with at the end of the entire exercise, therefore, his issuance of notice stands validated. That it is in this context I'm submitting. If your lordship holds that, no, even if the removal is set aside, it does not validate the issuance of notice in any way, because there was a controversy as to who the chairman. And at that point of time, the judicial orders which were holding the field had held. And of course, it was stand of the government also. To a different council, that's not the issue, that the orders were bad in law. And therefore, Vikash was not in the scene. It was only Sanjay. If that view is held, then we need not come to this part whatsoever. Now, it leads to the conclusion part. Can there be two AGMs of a society? Certainly there can be two AGMs. When? This I put to myself. It is when I try to convene an AGM, the quorum falls. Quorum falls. There can be two types when the quorum can fall. Number one, in the first hour, I do not have the quorum. It's an adjourned meeting then. It may be so that I have the quorum in the first hour, the meeting commences, but then the quorum drops.
Then every time it is a adjourned meeting, it can't. be said that
Absolutely,
there is
it
two-
absolutely, my lord. I was on that. This, it will be a adjourned meeting, which we may call a second meeting. But one meeting, if it is not an adjourned meeting, my lord, it has to sail or sink. There cannot be second meeting. It has to sail or sink. Approved or not approved. The consequences, the board remains or gone. It is not that we had not convened the meeting in time. We had convened the meeting time. Approval not granted. All right. If the approval not granted is tested by your lordship in our favor, the board says,
What is a better option when four honorable judges have taken up this matter in different points of time?
I can,
No,
three.
between sail and sink. Which is a better choice according to you?
Whatever lordship does it, the lordship takes a call. 29 AGM was correct for two reasons. For two reasons it was correct. A legal and a technical. The legal point would be that it was through the pen of the chairman, who was held to be the chairman by the registrar and not challenged anywhere. The technical point would be it was made known to the court in the course of the proceedings. That's what I'm saying. There was not objected to also. No, it was there. And we had also told the ROCS that the second one should not go. They cannot be, as I followed from your lordship, the idea was building about my lord, that if it's an adjourned meeting, very well, second, third, fourth, whatever you do. But if it is not a adjourned meeting, either the meeting stands or goes, I changed the word. Therefore, my lord may adjudicate 29(9) as a second writ petition, and the fallout would have an absolute bearing on the other two. And they cannot improve on the reasons for removal, save and except that Sanjay Das is not the chairman now, but was there. Only that now. I rest my case.
Yes, Mr. Hope.
One thing, Lordship.
We have to stop you.
Vikas has issued the notice of the
We'll have to
annual-
stop you.
Lordship. Vikas Das had issued the notice pursuant to the resolution of the Board of Directors, Lordship. There is a, before holding the annual general meeting, there is a meeting of Board of Directors, where 8 members of the Board of Directors said pursuant to the section
That we have taken note of.
10, Lordship hold the annual.
That
issue
we have
the-
taken note of.
Without approval of the board, Lordship, Vikas Das did not issue the notice, Lordship. There is a concurrence from the board, Lordship. In 14/9/2023, there is a board meeting, Lordship. Pursuant to this board meeting, annual general meeting is held on 30/9/2023, Lordship. He himself not issued the notice of for the annual general meeting, Lordship, being the secretary, Lordship. As per the direction of the Board of Directors, Lordship, board meeting, we have issued the notice, Lordship.
Yes, last. Please slip of your names. Declaration wise, give your names. We'll have it on. So heard, so arguments with the consent of all sides, some arguments have been heard at the motion stage in WPC. One 1975 of 2024 and WPC 2094 of 2024. In view of order dated 19/4/2024. Next, similarly common. WPC 6243 of 2023 has also been heard with the consent of WPC 6243. The consent for all sides in the admission stage. Arguments concluded, judgment reserved.
Bless me.
Item 4 with 5.
Item number 4, there is IA, madam.
I think in other matters, we won't have time. All other matters will be adjourned. Dates, we are not fixing it right now because since all the matters are rolled over, we will not be doing dates. Maybe registry fix those dates.
Lordship, I am appearing as petitioner in person. It will not be convenient for me to look after the cause list daily. So please fix that.
Item number?
Item number 8.
Item number 8, give a date.
Yes.
Okay, we'll give a date. Let the court give a date after some time. We'll do it. Yes.
Lordship, please. There are two matters.
This I is by?
I is by
Let me open them.
Item 4, madam.
No, but you see, there's a judicial order of 27/3/2024
Yes, madam.
that the writ petition will be taken up
Yes,
for
madam.
hearing. So
Yes.
IA is part of it.
Yes, madam. So, madam,
Open.
morning, madam, then regarding the IA, it will be dismissed, madam, if time taken. So, madam, this.
So let him start with that.
So there are two writ petitions filed, Your Lordships. We will be concentrating in 4811. The second writ petition. They are consolidated, all the facts are available in this writ petition also.
4811.
4811, yes. Your Lordships has it?
Yes.
Yes. This matter relates to a contract. There are actually two contracts. We are now concentrating on one contract. The contract number is 1698. This was being given to the petitioner on 9/4/2013. Subsequently, when this contract was given for earth filling work for a guide bund for protection of an embankment at Jogi Hopa. That was the purpose of this, which the contract was awarded to us in the year 2013, April.
Subsequently, after the award of the contract, I'll just give your lordships the facts as to why I'm here before your lordships today. Subsequently, we received a letter from the railway saying that please hold on, as of now, please don't continue the work because there are certain financial problems that the railways are facing towards this project. Subsequently, on August 2014, in 1st of July 2014, we were intimated that you can now start the work. The contract is actually for 6 months. Since that period had already expired, I wrote to the Railways Authority saying, please give me an extension for the work to continue to work and start working. Now, if your lordships will keep in mind that from 2014 to 2022, now that's an admitted letter on record, there were various occasions in which I had applied for the extension for whatever reasons are mentioned in the letters, and the extension stood granted to me. Once the extension was granted, the last extension that I got was on 24th of April 2022, that lasted till 31st of March 2022. Subsequent to this, there was an additional land acquired. Now, the additional land acquired is by their own letters, they admit that because the land that was taken initially could not be 100% taken by railways because there were a lot of objections from the villagers. There were incidents of violence that took place. However, the land, according to us and also by letters that are on record, shows that till a particular time, the land could not be acquired by railways also. So one of the reasons that every time I write a letter for extension, the extension stood granted to me. Subsequently, when I wrote to the railways that I am ready to work, they told me that on March 31st, your extensions have all ended. So please apply for an extension and start the work and complete the work. This is in 2022. The contract is of 2013. Subsequent to that, I applied for an extension on their request. They had an occasion to say that this contract is now being not fulfilled. So there was a situation that they could have terminated me, but that didn't happen for whatever reasons best known. I was subsequently applied for an extension. And this extension letter, your lordship, is of 27th of May 2022. Subsequent to this, your lordships, I received a demand notice from the department.
Extended time.
Yes, that extension is also in dispute now, your lordship, because that was granted much after, which I never knew when I first came to court to file the writ petition in terms of the demand notice that was issued to me, because I never knew the extension was granted to me. I only came to know much later when I filed the writ petition, the writ petition, which is 4030, in terms of challenging the demand notice that was issued. And on the same day when the demand notice was issued, an amount of 10 lakhs from a different contract, which is 1689, was deducted, 10 lakhs. And the reason that was explained in the counter affidavit is because apparently behind my back, which I did not know till the notice had come to me, the demand notice, there was a vigilance inquiry that happened. No notices. I was never put to knowledge. I was never allowed to lift my case or present my case before the authorities. There was never anybody who visited, inspected my documents, nothing. I never knew that there was an inspection, that there was a vigilance inquiry going on against me. In terms of the vigilance inquiry, which I don't have a report, therefore I couldn't even challenge it. They have decided to deduct this money from this contract, which, your lordships, there is a clause in the contract of the railways which says that yes, they can do it if due to reasons explained in the contract. So they go ahead and deduct that money. Subsequently, there's an interim order passed by this honorable court. The interim order says no recovery. After that, in a span from June to July, August or September, your lordships, I received 4 letters. In all the 4 letters, I was intimated that you have to complete this work within so many days, failing to which we will terminate your contract. These letters were replied. I have given them all the explanation that has been given, inclusive the fact knowing that I did not know about any investigation that was going on. I have already written to you, all extensions have been granted from 2014 to 2022. They said that the land was given to me in 2018, when they their own admission that till 2022, nobody could go to the land because there was no accessibility to the land also. Subsequently, your lordships, I come to know that on 14th of June, I was actually allowed an extension for my letter that I submitted, and that extension was till July 31st. Unfortunately, I then subsequently been after served with the 2-3 notices in reply. I was subsequently terminated on a particular date of 11th of July. Within the time, the extension was still existing. I immediately came before it.
This is a railway contract where it contains arbitration clause normally under.
Yes, it does, your lordships. I'll come to that. I'll come to that. There is a 100% there is a clause existing, but there is also something which is available as a right. I'll read that to your lordships as I come before and I show your lordships the documents everything. I will, yeah, which has to be exercised prior to the arbitration, which with due respect has not happened. I will point out to your lordships. May I just take your lordships to the documents now? The annexure 1, your lordships, to the petition is the contract. I have only extracted the relevant part of the contract, your lordship, because the contract is very big. The date of the contract, your lordships, is 9/4/2013. Annexure P1, page 54, your lordships. Yes. Yes. And the contract number is 169.
Just
I'm
a
sorry.
moment. These are two writ petitions.
Yes, your lordship.
Can you give me a consolidated list of dates?
I have, if your lordship wants.
First one, my lord, they regarding to my lord, the recovery, my lord, first one. The second one,
I-
regarding termination of contract, my lord. And my lord, in first one, my lord, there is an interim order, for particular time, my lord, and they have it was not extended, my lord. And second one, my lord, the, regarding to the termination of contract, my lord. It is, still, my lord, it is there, my lord, no, we have not published another NIT, my lord.
You have not?
For the base contract, we have no, there is no, person from the railway authority. Because my lord, it is 2013, now 2023, it was after several years, his contract was terminated. And it was only for initially for a period of 6 months.
This list of this is quite precise. I'll give your lordships later a comprehensive one. This is only to correlate with the documents that are mentioned in the written petition, just for your lordships' convenience. So the annexure is, that I'm relying right now is page 54, annexure 1 is the contract.
Yes.
Yes. Page 54, annexure 1. So the contract is 9/4/2013. The amount of the approximate cost, page 54.
Yes.
Yes. The cost is 5,76,61,203. And the number of the contract agreement is important. It is 1698. So that's the contract that we are now pursuing. And just 6 lines from the bottom, your lordships, which is marked in bold, it says that the condition of the contract on or before 26th of March 2013 and will maintain that the said work for a period of 6 calendar months. So the period was 6 months for which this contract was granted to me to complete this earth filling work. Now your lordships will come to page 83. I'm sorry, page 84, your lordships. First, we'll read 83, your lordships, on the bottom, and then we'll go to 84 on the top. 83 says, modified clause 46.0. May I just read the lordship's permission?
Yes.
Lordship, please. Modified clause of GCC, clause number 46, clause 52, withholding and lien over respect of a sum claim. The word uses claim. Whenever any claim or claims for a payment of a sum of money arises out of or under the contract against the contractor, the railway shall be entitled to withhold and also have a lien to retain such sum or sums in whole or in part from the security, if any, deposited by the contractor, and for the purpose of the aforesaid, the railway shall be entitled to withhold the cash security deposit or the security, if any, furnished as the case may be, and also have a lien over the same pending finalization or adjudication of any such claim. In the event the security being insufficient to cover the claimed amount or the amounts, or if no security has been taken from the contractor, the railway shall be entitled to withhold and have a lien to the extent of such claimed amount. The word is claimed amount, or amounts referred to supra, or for any sum or sums found payable. The word is payable, or which at time thereafter may become payable to the contractor under the same contract or other contract with his or any other railway or department of the central government pending finalization or adjudication of the same claim. So the claim that was adjusted in terms of the 3 crores demand notice was based on this clause. However, the word used is claims, which they say has to be claimed amount, has to be claimed, amount which is claimed and found payable. Right. May I just come to the bottom of the page, Your Lordships? It's clause number 63 now. Your Lordships had asked about an arbitration clause. This is clause 63 in the middle of the page. Matters finally determined by the railways. All disputes and differences of any kind whatsoever arising out of or in connection with the contract, whether during the progress of the work or after its completion, and whether before or after the determination of a contract, shall be referred by the contractor to the general manager, and the general manager shall within 120 days of the receipt of the contractor's representation make and notify the decision on all matters referred to by the contractor in writing, provided the matters for which so and so general clauses are certain clauses which are not applicable. So the first step is the moment a dispute is raised, which in terms a show cause, a demand notice that has come to me, I reply to the demand notice. The clause says it shall be referred to the general manager. So the first step is it has to be decided by the department, by the general manager within a span of 120 days. Unfortunately, the moment demand notice was issued to me, on the same day when the bill was raised for a different contract, without even deciding, without even giving me that time that I'm entitled, they have gone ahead and taken that money of 10 lakhs rupees, which was raised in terms of the claim that that amount is not even an admitted claim, according to me. So the clause is, it shall refer. So the dispute has been raised by them. I reply.
Please repeat your submissions. You're saying that the general manager has
The
the
moment-
power
Yes,
to be
what I'm
informed
trying to
about.
impress on your lordships is the moment there is a claim that is raised when the contract is in substance or when the contract is completed also, the moment there is a dispute which is raised by the department in terms of the notice that I have received, which is annexed in this petition, I was allowed to have been allowed to reply. And then it should have gone through the process of that office who's supposed to decide this. And then the step is taken as to whether the deduction is required or not. Now, in claims of the fact that, yes, the right still exists, that they can deduct the money from a different contract, but it has to be done before, with this process has to be completed. And this has to be a claimed amount.
Where is that in this clause 64?
Yes.
Event of
Yes,
any
63, your lordship. The progress or any work on the third line and after its completion, whether before or after the determination of a contract, shall be referred. That's the third line. By the contractor to the general manager, and the general manager shall within 120 days after receipt of the contractor's representation make and notify the decisions to all the matters.
So therefore, when this money was taken away from that the other pending bill.
Yes. So there were
you
two
could have-
contracts.
you-
Your Lordship.
You could have still exercised this power of informing, raising your protest.
Yes, so when I reply to the notice, that reply itself is to the department saying that the dispute that has been claimed and I'm denying the dispute, this is not correct. So that letter had gone on to, I think, 2nd of June. And the notice that was served to me was 23rd of May. That is at page 149. The demand. That's a demand notice, I'm sorry. That's at page 149, your lordships. For the recovery of money.
Yes.
And if your lordships will come to page 154, which is annexure P12.
Yes.
At page 154, annexure 12, your lordships, it says authority for the work, if any, CA number con MNX JPZ 1689. And the contract that I'm referring is 1698. So this is the bill that was raised on 24, and the deduction, your lordships, is available at page 158. This is 10 lakhs. And on the left, your
What
lordship,
is this annexure 12? What is the name,
This is-
nomenclature of this?
this is the bill that was raised for the work
Annexure
done in a
12 is-
different contract.
Annexure 12 is your bill.
Yes. In a different contract, which is 1689. And on the left, it is written, recovery made as per CVO dated so-and-so, government so-and-so, and the contract number is mentioned just a small 1698. In-
Which page?
That's at page 158, your lordship, where they have deducted the amount on 30th of May, 2022. On the left, if your lordship sees, it's written by hand.
Yes.
Recovery made as per CVO, and the contract number is just below that, 1698. On 9/4/2013. So the 1698 is the contract which is before your lordships, and the bill was raised at first page at 154 is 1689. because it says that you can recover it from any other contract existing with them.
Recovery is 10,91,850.
Yes. Subsequently, the entire recovery is done in the months in demand to the demand notice that was raised.
There are other recoveries also.
Subsequently, they have raised it. I mean, they have recovered the entire money. I do not know as to how they have recovered, but they have recovered. They have put it on an affidavit also. I'll just show you lordships from. I'm sure it will be from other contract because this contract is.
Okay, what is the demand amount?
Yes, your lordships should see find it at page 149. 23/5/2022. The demand amount is 3 crores 47 lakhs. Third line. 3,47,08,946.9.
Yes.
Lordships now turns to page 150 with this demand notice, which was served on us. There were 3 or 4 letters that were annexed, your lordships. At page 150 is 12/5/22. Page 151 is 5/5/2022. And at page 152 is the calculation how the demand has been made. And at page 153 is another letter which has been annexed in where they have said that there is an inquiry which has happened against me. All these letters, your lordships, were never served to me before. There was no show cause for this entire issue. It was straight a demand. Page 151 is important because that's where they say that it is in terms of the vigilance inquiry that the demand notice was sent to me. That's a clause 1 and 2. As communicated, referred above, Railway Board has conveyed advice of the Central Vigilance Commission, whereas Central Vigilance Commission has advice for recovery of 3 crores 47 to the contractor within a timeline. So this is the basis on which they have issued the demand notice to me. Admittedly, no show cause for this. And my reply to this show cause notice is of 2nd to my demand notice, your lordship, is 2nd of June 2022 at page 159. So didn't even wait for my reply.
Coming back to this clause 63,
Lordship.
at page 84,
Yes, sir.
that show cause, opportunity of show cause,
Yes.
even if it is not granted, but if you are agreed by the recovery is already made
Subsequently, Your Lordship.
subsequently,
Yes.
it will still be a matter which will be arbitrable.
Covered by 63, because the moment there is a dispute raised, I should get the benefit of this within 120 days, and then it becomes arbitrable. I'm not saying that, yes, I have every right to go, or they can go in an arbitration. But with all due respect, I believe this is the first clause that has to be first covered. I get that opportunity, and then the amount which is actually deducted becomes an admitted amount. It says an amount which is payable and admitted. So that, according to me, there was no opportunity for that. Had the show cause been given, Your Lordships, I would have perhaps gone and defended my case to say yes or no, that amount is demandable or payable or not. That never happened in my case. So I had to accept it, the fact that the demand was unilaterally done and unilaterally taken from me. So that's my case. Arbitrable, yes, Your Lordship, it is.
Page 83,
Yes, Your Lordship.
you are referring to modified clause.
The contract, which says that you can withholding and lien of the respective sums, has to be found payable at page 84.
In the event of any security being insufficient to cover the claim amount, influence payable to the contractor, entitled to withhold and have lien over such claimed amount. Or amount referred to the claimed would be the claim made by the contractor.
This is a stage one step before this, which means I have to be show caused, I have to be heard, adjudicated, and then perhaps, yes, Your Lordships can obviously deduct the amount. There's no problem in that. So here is a situation, Your Lordships, where the show cause was never issued, for which I could never go and defend whether that amount that was deductible or the show cause amount is actually, demand notice is actually entitled or not. That opportunity was taken away from me. This is absolutely applicable, provided the first step with due respect is compliant. So without an adjudication, amount.
I'm able to read it with you, same thing. Because it says that the extent of such shall be entitled to withhold.
Absolutely.
You have a lien to the extent of such amount.
If found payable.
If found
payable.
Not found payable.
So found payable, Your Lordship, then it has to go through a process, which unfortunately could not happen in my case. There was a demand notice.
No, from any sum or sums found payable.
Yes.
So the bill which you have raised.
Yes, Your Lordship.
Is deemed to be amount payable to you, and therefore they have recovered it.
So it, I'm just trying to say, if this, Your Lordship says, yes, they're right, they have a right to take it away, but with a process that I have an opportunity to defend that.
But where is that?
That is what 63 is all about. It says first right is the moment a dispute is raised, whether in continuance of a contract or subsequently, Your Lordships, it shall, which means any of the people who come up with this will have to be first decided. Then they have a right to adjust it or take it away. There's no problem in that.
That's why you see 63 says shall be referred by the contractor to the GM.
Correct.
Now you can still raise this and then the GM will decide.
Yes.
And within 120 days.
Within 120 days, decide it. And if it is payable, they have a right to deduct it. That never happened.
No. Even post deduction.
Yes.
Still that can be raised, it can be raised as a dispute within the meaning of section 63, and you will respond to it and then
Unfortunately, it was never done, Your Lordship. So 2000, the demand notices of May, I came before Your Lordships and the first writ petition was filed after subsequently to the adjustment. Until date, with all due respect, that was never, this clause was never invoked. They could have done it perhaps. Your Lordships are right. If it could be done post and not pre,
no,
I
that
still
will-
have
that will
some
be the
opportunity to be
contractor-
adjudicated.
No, that will be for the contractor to invoke.
So I have already replied to the demand notice by saying that I am not entitled to pay. So that raises a dispute, Your Lordship.
No.
And that is at page my reply is at Your Lordships at page 159.
Have you made the demand for arbitration here?
No,
So then,
I have not, but I have said that the amount so raised and claimed,
no. Mr. Pugan, there's a difficulty.
yes,
You raise, some money is deducted from you.
Yes.
Without any show cause, without giving you an opportunity of being heard, correct? Now, irrespective of whatever the amount of demand is for, or recovery is made of 3 crore or not, let us say some money is recovered from you. Now, you are agreed by that
Yes.
action. You can still raise an arbitrable dispute, and if the GM will decide about it, and then it goes to arbitration.
yes,
You see, before deduction that you will have to be issued a show cause.
yes.
And only after that there will be a deduction. That is a clause which I am not finding.
So that is why the reason I came before Your Lordships and was protected in the first writ petition that was filed was because the entire exercise was done in complete violation of a principle of natural justice. And that is why Your Lordships protected me. And in spite of that protection, Your Lordships, in their reply also, they don't say that. They don't say that you are entitled to go under that. So they admitted the fact that the writ petition that is filed in terms of a deduction, where an interim order was granted that you cannot recover any amount of money. So the entire issue was then transferred to this. So the invocation that I am supposed to do already happened when the deduction happened. So I lost my chance and I came before Your Lordship for a protection by saying that, had the show cause been done, even post Your Lordships, I could have perhaps gone and taken a recourse to this clause 63. But since I didn't have that option left, I came before Your Lordship because I said there is a violation, qua that. And that is natural justice. And that's the order which is passed.
Natural justice can't be read into a contract by saying that when the respondents have power and authority to recover their dues, whatever dues, whether you get a show cause notice or not, according to them, it's a recoverable amount and they have recovered it.
Right.
Before that, you will have to be heard.
Yes.
That is not a part of the contract. Because whatever is happening is we are all, this agreement is a creature of contract.
But if it has civil consequences, any action, if it has civil consequences, I have a right to be protected. So therefore, principle of natural justice has to be followed, especially in cases of these kind of natures.
Any authority on the point?
I give it to Your Lordships. May I just, if it is not inconvenient, may I just read through this so that it will become easier for Your Lordships to understand why I am. Then after that happened, Your Lordships, I filed a writ petition. It's at page 165.
Yes.
Yes, page 165, Your Lordship. That's the first writ petition that I made in terms of the deduction and as well as the demand notice that was raised.
Yes.
The part that I want to read your lordship is at page 167. It starts at 166. It first gives the factual aspect of the order. And then it says 167, the first line from the bottom, from the top. Acting on the demand notice dated 23/5/22, the respondent railway authorities have recovered an amount of so and so on 30/5/2022, which recovery has been made by the respondent authorities from dues payable under the contract agreement dated 9/4/2013. At this stage, the learned counsel so and so has two aspects. Number one, there is a violation of principle of natural justice, as no prior show cause notice was issued to the petitioner, providing him an opportunity to explain as to why such recovery should not be effected, and the respondent authorities has arrived at a figure without any participation or from the petitioner. Number two, the recovery is allegedly attributable to the contract agreement of 2/4/2003, but the recovery has been made against another contract and the agreement dated which the petitioner is not permissible. Now that was the one I said in terms of the first contract that was existing. And subsequently at page 168, the interim order is passed, your lordship. So it says, having regard to the projection made in the writ petition, no prior show cause notice was issued before the respondent authorities have demanded an amount of so and so as recovered from the petitioner. It is provided there will be any further recovery till returnable date. May I just take your lordship to page 171? It's the letter which the respondent authorities has issued to me in terms of the last extension that was given to me, which expired on 31st of March 2022. And if your lordships will see, the date of the letter is 14/6/22. The competent authority has granted an extension of the DOC of the work against the above quoted contract agreement from 1/4/2022 to 31/7/22 under clause 17B GCC with a token penalty of 5,000. You are requested to complete the balance work in respect within the extended validity without fail, please. Now, if your lordship sees, the date is 14th of June. The letter that I gave in terms of my expiry, which was the last extension granted, was much later because I did not know at the time when I filed the writ petition that the extension was actually granted to me. So that is why the order passed is on 24th of June. The High Court order that was passed by your lordships is 24th of June 2022. And this letter is 14/6 because this letter was subsequently given to me. There's also a controversy in regards to this because we have said the letter is not being served to us, whereas they are saying that the letter stands served to us. Unfortunately, this letter was sent to me by WhatsApp, and I have put it on record, the WhatsApp record. And subsequently after this, your lordships, within a span of 3 months, they have said that you complete the work in 15 days time first, then 7 days, and subsequently on 11th of July, because the extension is up to 31st of July 2022, they go ahead and terminate my contract. During the subsistence of this extension period. That is why I came before this writ petition that your lordships are currently looking into. And I have filed a writ petition saying that the termination is illegal. Now, may your lordships take your lordships to the first part of this at page 120, 127.
Termination was 31/7/22.
No, your lordship, termination is 11 July. And the extension that was granted to me, your lordships, is till 31st of July, 2022.
11/7 you were terminated.
Yes. That termination letter is at page 181, your lordships, annexure 22.
Yes.
Yes. 48 hours. This letter is addressed from the respondents to us. 48 hours notice was given to you under the office letter dated 8 July 22, but you have not taken any action to show any progress of the work. Since the period of 48 hours has already expired, the above contract stands rescinded in terms of clause 62 of the contract, and the balance work under this contract will be carried out independently without your participation. Your participation, as well as the participation of every member partner in any manner as an individual or a partnership firm JB, is hereby debarred from participating in the tender for executing the balance work. So this is the termination that I received on 11th, was sent to me again by a WhatsApp message, which I have already filed in. Now, your lordship, the entire essence of the first writ petition was the fact that my extension was always in question. From day one, when the contract was started and finally handed over to me after whatever the problems department faced, till 2022, my case is that the extension stands granted. And the reasons of the extensions are mentioned in all the letters that have been issued by me. That, your lordship, starts from page 127 of the writ petition. Page 127.
Yes.
This is the first letter I issued on 13/6/2013, page 127.
Letter for extension.
Yes, this is the first letter of extension. 1/7/2014. Simultaneously, your lordships can refer to this note because here all the extension letters are, and the dates are mentioned. Then 1/7/2014. 13/8/2014. 23/8/2014 extension granted, 31/3/2000 without any LD. 23/2006, 131. With reference to the above cited, I honor to inform you that the validity date of the above mentioned work is already expired, but due to following major reasons, above mentioned work could not be completed within the completion period. So I need an extension for validity of the final completion of the work. I therefore request you to grant me an extension for the validity period of work up to 31 May 2017. And the reasons are mentioned: number one, due to site has not been handed over to me by the railway authority, and the authority told me that they have not acquired the said land. This is a major cause of work. Number two, there is no road to carry out the materials to the working site due to deplorable conditions of the approach road. And number three, due to monsoon and heavy floods. This was replied on 4th of March on the next page is 132, Your Lordships, where the extension stands granted. Then on 29/8/2016, I again applied for an extension. And the reason mentioned at 133 is again that the site has not been handed over to me, which is a major cause for the delay. And at page 134 on 1/9/2016, the extension is granted to me. At page 3/10/2017, 135, again an extension is sought. And the reasons are again heavy monsoon, site not handed over. And the land not being acquired. Page 135, reasons at the bottom, the 1, 2, and 3. And again at 136, the extension stands granted to me. The last extension is 24/2/2022 at page 142. Competent authority has granted the extension of DOC work against you above quoted contract up to 31st March 2022 under clause with token penalty. So it was after this that no further the extension was granted to me. I subsequently, they had an option to terminate my contract for the reasons explained here. However, they then write to me saying you must apply for the extension if you want to complete the work. Those two letters are Lordships have marked at page 146 and 147. Those are issued by the department to me. Those letters are 13th of May 2022 and 21st of May 2022. So the first line says, Your Lordships, that in reference to the above, it is stated, the work has not been completed by you, nor applied for an extension for validity of the above contract, which has already expired on 31/3/2022. No application is received from you so far, though it is requested on several times, either on personal contact or over the telephone. However, on the last line, it says, in view of the above, I once again request you to apply for extension with valid reasons and deploy adequate manpower, material, machinery to complete the work within time. And a similar letter was also raised on the next page at page 147, 21/5/2022.
It's a date.
Yes, Your Lordship. I'm sorry, Your Lordship's been tired the whole day. There was a hearing happening.
I know that I have a meeting.
Oh, I see.
Actually, I was yesterday I was not well, so yesterday I was not well, so I morning get that. Yeah, case in mind, the already sufficient time was in extension was also given, 2019, there's no work, there's one, there's vigilance was there.
And interestingly, when the last extension was granted, Your Lordships, the letter says that the vigilance inquiry already happened by then. They have completed it.
19,
That's what the letter says.
2019 April, my lord, 19 April, no work, no work.
20th of April.
Everything is there.
Anyways, 6 months work.
Yes,
Extend for 16 years.
my lord, there is, my lord, some official, there is some, their action also taken against some official.
Mr. Abdul Kader, counsel for the petitioner. His submissions remain inconclusive. Mr. Estimated Leonard, this is present. List one, this was a part of matter one.
Ninth of May, my lord, possible. 30 তারিখেও দিব পারি, 30 তারিখ মঙ্গলবার দিব পারি।
30,
3 April. Yes, ma'am. 30/04. 30/04. I'm ready, man. But my friend has some personal difficulties. He's in Orissa.
Naturally, worships on 29th and 30th.
My 9th of May, my lord, 9th of May.
Any other date that is convenient to your lordships. I'm sorry for the inconvenience caused.
no, it's okay.
I-
9th of May, my lord.
Can it be on second, your lordship, which is the
Second, my
Thursday?
lord, second of my,
You're not there.
yes, no, 9th of May, my lord.
9th of May is fine. If it is not inconvenience to your lordships.
দিব পাৰিব 9th of May
9th of May.
This is a partner. As a website.